Good morning. Happy Thursday. I am running late because I poked myself in the eye with my mascara. Anyone who's worn mascara knows that it's a whole situation. Then I had to wait for my eyes to stop watering. It was a mess. But I've got my coffee. I've got my Cursey words. We have a lot to talk about today. We've got so much going on. It's just going to be a busy day. So hopefully you guys have seen the topics for the day. Did I talk about them yet? No. Are we prepared? Sort of. Are we always prepared? Kind of. I mean, it's going to be a Thursday. And again, I'm still trying to get my eye to stop watering, which is making my nose water, which after being sick is just mess. It's just a mess. So today we're talking about the Rust settlement. Of course, there's some interesting items on the docket that we're going to pull up the docket and talk about. We've got a lot going on with Cardi B and Tasha K. Did you guys see that it's being reported that Tasha K only has like $1,000 in her bank account? We're going to talk about that. And if you want to, we'll get into the appeal because the appellate brief was filed. So we'll talk about that. And then hopefully we'll have time to get into the Onion parody Section 230 platform transparency. We're going to talk about all of the things. So let me know where you're coming from, what you're coming in on. I see a lot of questions in the chat, so we will answer some of those before we get into our topics. I think I forgot to share this. I'll go share it. We're a little less congested, which is good. I know there are trials streaming. I'm not streaming the ongoing trials right now. I will take a look at them. I've got a busy week next week with BravoCon. The current trial that's going on, the vehicular killing of multiple, I don't remember off the top of my head how many people were killed in that Christmas parade. That trial is going on with a defendant who is representing himself pro per. I have done pro per trials. They are, we can talk about that. They are a whole situation. If we want to stream some of that trial, I will take a look. I want to see how that starts to unfold because it's probably going to be tedious. It's going to be like a month-long trial. So if we want to do some of that trial coverage, I will ask you guys when I am back to a more normal streaming schedule after I travel to New York and see if that's something that y'all are interested in. So with that, yes, the Darrell Brooks case, it's a lot. It's a lot. We can talk about it for a minute, but that case is starting today with opening statements. So once we roll the intro, I'll get into what it's like. If you guys want to know what it's like to be the prosecutor on the side of dealing with a defendant, non-lawyer who's representing themselves, which they have the right to do, but can be very difficult for everyone involved in the case. So we will see what's going on. But coffee, I see where you guys are coming in. Let's go. Stina said it's tedious. She's reading the charges now. Well, that's going to be the morning. They're going to be reading charges this morning, and then they're going to be reading jury instructions and things like that. So EEEE asks, are you going to BravoCon as an attendant or as a guest on stage? Attendant. I am just going as an attendant to go see the people, to go see everyone and do all of that. So Tasha K has a video out that says she is at negative 42.45 in her account or something like that. I'm not surprised by that. Stephanie said, don't want coverage of the entire trial of Darrell Brooks, interested in hearing about competent to stand trial. And we can that might be a good topic of an episode, is how we get here with people representing themselves. And then if he testifies, maybe talking about that and figuring out which part of that trial. But if you want to, it's streaming all across the interwebs. So let's, a Philly Girls Weekend sounds fun. Let's get to all the questions. So any updates on the H3 lawsuits? I need to look because there should be a ruling. There was a hearing about the anti-SLAPP. We should see a ruling from the anti-SLAPP, but I have not seen one yet. There's a lot of trials coming up. All right, let's roll the intro and then we'll keep talking. We have lots to cover. So let's roll the intro. Let's do that as I finish like getting stuff ready. I should probably share that I'm streaming. We're professionals here.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
I totally forgot to share out that I was live. I did text the text crew. We did text the text crew. So I'm going to go through a few of your questions. A lot has gone on the internet in the last few days. So there's, well, in the last 24 hours. So there's no way around talking about that. So we're going to talk about it at the top of the stream and then get into all of our stuff. So anyway, with that, I'm going to text this out, tweet this out. It's not going to get shown to anyone because I'm going to put the link in it. But for those of you that do follow on the Twitters, we are sharing that out now. I said we are live. No, I should say I am live. What's with the royal we, Emily? I don't know. I are live. No, we. Join the law. Us as a community, we are all live together. Join. Yeah, anyway, I know a lot of people are live this morning. I saw a comment saying that Natalie Lawyer Chick is covering the Brooks case. Natalie Lawyer Chick is a perfect person to cover the Brooks case because she also is someone who covers a lot of sovereign citizens. He says that he is a sovereign citizen. She has a lot of information on the way sovereign citizens operate in court, and that becomes a very delicate situation for the court and for the prosecutor when you're looking at someone who's representing themselves. It's a difficult thing for prosecutors to make sure that they are protecting any possible conviction, making sure that the Constitution is absolutely adhered to, which they always should do. Always. But when you don't have a lawyer on the other side, it can be very difficult to make sure that everything's on the record. Normally, when you give a defense attorney discovery, you have them sign for discovery and you don't have to go through, this is every piece of discovery we turned over. There are things that a defense attorney provides protection for and provides professionalism for when someone's representing themselves. That's not an attorney. That can become very difficult. And I think what we will see in this case, if you're watching it, is that the court will be going kind of above and beyond to over-explain. We've seen some of that already in this case. And the court's not allowed to tell them how to do things. The court's not allowed to tell them how to ask a question or make an objection or what the objections are, what's proper evidence. But the judge also has to make sure that this person can competently represent themselves. Competently doesn't mean as well as a lawyer. It means that they actually understand what they're doing and they have a right to do so. And that takes a lot of work. It ends up being much more exhausting, and it is very difficult on the witnesses and any victims, surviving victims. There are quite a lot of deceased victims in this case, but any surviving victims or witnesses, because they're being questioned by the person who did the thing. The pro se trial I did, that I have a very clear memory of, and I've done a lot of pro se or pro per representing themselves, pro se or pro per hearings. The one trial that I remember really vividly was an individual who was stabbed at their workplace by somebody who came into the workplace and was trying to rob them. And it was very surreal trying to prep a victim for the person that did this to you is the one that's going to be asking you questions in your face. And so the pro per kept saying, you say the defendant said this. And the victim would be like, you said this. He's like, why do you say the defendant was there? He's like, I saw you. But this was a victim who was very prepared for having to see the person who did the thing to them in court. But it's still very difficult for the witnesses and to question them. And it can sometimes be used as a tool of intimidation. I don't think that's what's happening in the Brooks case. I don't think he trusts attorneys or the government or the attorneys that would be appointed to him or the system. I don't think he believes he is subject to the system, which is what gets into what a sovereign citizen is. He does not believe, and I am not an expert in sovereign citizens, but does not believe that the authority of the US government applies to him. So I understand not wanting a defense attorney who's appointed by the government, et cetera, et cetera. Sorry, my internet got weird for a second. Apologies. Hopefully now it's resynced. That was weird. So sovereign citizens don't believe that they have to adhere to the rules of the US government and that the US government does not have control. Natalie Lawyer Chick has a ton of videos about sovereign citizens. It's something she's dealt with in court quite a lot, and that is a great resource if she's covering this case too. She does great content. So, with that, we should talk about all the other things. So I'm going to answer a couple of questions, and then we'll get into our topics. Daryl Brooks currently has his objection sign. He's on camera in another court because he cannot behave, stuffed down his pants because he is tired of holding it. I mean, he keeps holding up his objection sign. The court has tried to create a circumstance where Brooks is not disruptive to the process, because that's part of it. I think they're going to end up doing a hearing at some point on whether he can continue to represent himself or whether an attorney will be appointed. And this is where constitutional rights can be difficult for the court, because they want to protect his constitutional rights, and he has the right to choose to represent himself, even if it makes the process more difficult, even if it's not what's legally best for the individual. And that's a push-pull of the court having to say they have the right to do this. This is a terrible idea, but they have the right to do this, and to let people exercise their rights, even when they exercise their rights to their own detriment, which is what I think you're going to see in the Brooks case. And that's tough. Philistine said, first time live, hi. Thoughts on the Try Guys drama? If it goes to court, I'll talk about it. It all makes me kind of sad, and I think it's very hard for them to deal with. I think the video they put out was probably a great example of how you address something going on with your company. And I think they did a good job addressing it. But if there aren't any court documents, it's not really what I cover. The whole thing just kind of makes me sad. Covering Danny Masterson and Weinstein next week. I will definitely be covering some of Weinstein. Is Masterson starting trial next week too? I don't know if any of those are streaming, but I will definitely be keeping up on them. I've seen an influx of interest in the Weinstein case. I will be asking all of y'all if you're interested and what cases you're interested in. There is going to be even in the Spacey case that I believe is also starting, there is going to be very difficult testimony coming up. Those are things I might do on a podcast, because the topics are very difficult for YouTube. So we will talk about that. So we will, like, as a community, have a conversation about what we're covering and how we're covering. So would you look at the Masterson court case? The plaintiff's attorney was refusing to be fired. I have not seen that. Or the Manson court case. I have not looked at Manson a lot, and it's going to be after these 3 trials go through. Hello, Connie, over on the Facebooks. If you guys are on the Facebooks, there's a following thing over there. Just like if you're on the YouTubes, do the likey, subscribey things. Is sovereign citizen the same as pro se? No. Pro se and pro per, and I will use them interchangeably, means representing themselves. Sovereign citizen is someone who does not believe that they are subject to the authority of the US government. So that is a very, very simplified explanation. So a very simplified explanation. Chrissy asked the real question: can he use ineffective counsel or ineffective assistance of counsel? If you choose to represent yourself, no. You cannot appeal for ineffective assistance of counsel. You cannot appeal for, hey, I was advised to do this, or I didn't know. And the court goes through, and I'm sure that it was streamed when the court went through the hearing for him to represent himself and went through all the advisements. Also, the Pawnard in the back today is the elusive George. He took the seat first. Fred's out somewhere in the sun. So this is the all ginger snap George. All right. More than 3 of you have asked. And we are going to talk about LawTube streamer who does not call himself a LawTube streamer, but lawyer streamer on the platform, Nick Rekieta. We were here yesterday on the premiere for the podcast yesterday when all of this went down, and the chat was just like, Rekida's channel got nuked. And on YouTube, YouTube has a couple of different ways that there can be problems for a YouTuber or for a channel. You can have copyright issues, copyright claims, copyright strikes, things like that, where you can have a video taken down for copyright. You can have a video not monetized for copyright, things like that. Those are kind of one avenue. Then you can end up with community guidelines, which are terms of service problems. And those channel strikes generally stop you from being able to engage on your channel at all for a period of time. And I believe this is a third strike situation from everything that I've seen. If you get 3 within a certain period of time, your channel is deleted. It's not, you can't post anything. The channel is down. All of the content is down. Everything is gone. So that looks like what has happened. From everything that Nick Rekieta has shared, he has not been told by YouTube what the strike is relating to. I know that he is appealing the previous strikes, and we will see what happens with those strikes. I'm sure he will be talking about it on other platforms about what's happening with those strikes and appealing to YouTube. It is always a push-pull because the way that Nick and I engage on the internet is very different. Nick is very much on the radical free speech end where he is going to say all the things. I'm very much on the, I like my corner of the internet where we all agree to the rules. We don't be a dick. We have moderators. That's the way we engage. That's the way I engage. It doesn't mean I can disagree with people. Nick and I disagree on a bunch of stuff and still believe that they have the right to say what they are saying, and still believe that free speech exists. It does. And you can say what you're saying. And that's where the push-pull is. I think people have the right to choose to watch content, not watch content. I don't like when the platforms are not transparent and clear in communicating what they have done, why they have done it. So that's what I have a huge problem with. I also don't like when there are large campaigns, and it looks like there were lots of people trying to flag his channel. When there are lots of campaigns against people, and whether those campaigns are proper. I don't think those kind of campaigns are proper. I don't like it. I don't like when people are like, we're going to get this person deplatformed. If that person's not for you and they're not breaking terms of service, don't engage with them. And that's kind of where I kind of fall on that. The way I engage on the internet is the way I like to engage on the internet, but I'm not going to tell anyone else how to engage on the internet. My space is my space, but I hope that all platforms, YouTube included, are transparent when they do things. So that's what I hope that we see. So Heather said, you just made a contradiction. Either you are free speech or you want free speech moderators. No, I agree in people's right to free speech. I also want to moderate my space on the internet because I have the right to maintain my platform and moderate our community in the way that we have agreed we want to engage. So yes, I believe people can have free speech, but the rules of our chat here are don't be a dick. Those are our rules. Our rules are no name calling. Our rules are we're welcome if you're welcoming and don't be hateful. A lot of free speech, and this is the thing that's hard with free speech, is a lot of free speech when you have conversations about the internet, about what's allowed to be said, about private platforms, about Section 230, about where the boundaries are. The platforms are still private companies. So the platforms and the way that the platforms exercise their rules when they're not transparent is a big problem for me. I think there should be absolute transparency. And I think that the platforms aren't always transparent enough. I hope that they will be transparent. I hope that they will tell Nick why his channel was nuked, I hope that he will get answers. And I know that he will continue to fight to get his channel back, and we will see what happens. But just with so there's that push-pull of values, right? I value a space where people are compassionate. I value a community where we can have conversations. I value a community where we don't name call, we don't malign, we don't make fun. That's what I value. That's what my values are for the way I engage on the internet and the way we engage on the internet. But that doesn't mean I feel that others should be deplatformed because we engage differently. I don't like mass concerted efforts to deplatform people. I don't like when social media platforms don't tell people why they have been removed. And I think telling people and transparency is absolutely what I expect from the platforms that we're on. And that's what it is. So that's what that's what it is. So we'll see what happens. We'll absolutely see what happens. I know a lot of the law nerds don't engage in that. We will see. We will see what happens, and we will see what the platform says. I hope that they are transparent, and that's always my goal. That's always my goal. Mountains Princess brings up a story that we talked about a while ago, and we need to get back to because there was some in Tennessee too, with the license plates and whether what you put on a license plate is free speech or not free speech, and is not allowing vulgarity on license plate or curse words on license plate and things like that. Is that the government restricting speech or not on license plates? We talked about it ages ago, and we need to get back to it. It's a great conversation, and it's hard to have a conversation. It's hard to have a conversation about free speech truly, because a lot of free speech conversations are around speech that most of us find kind of abhorrent, because if we didn't hate the speech, it probably wouldn't have been restricted or silenced or what have you. It's always having these conversations around difficult topics, difficult speech. But I think conversations are important. And I think that platforms should be transparent and consistent in the way they mete out their rules. I think that's, if you're going to have rules and enforce them fairly, be transparent in the way you're doing it. I think that's the best that we can ask for, is know what the rules are. And that's what it is. So that's where we're at. Which Kelly said, lifelong motto, you do you, boo-boo. I mean, yeah. And that's really, the law nerds are like, look, don't be a dick. We're not going to name call. We're not going to be mean. And we're not going to allow that. I mean, depending on the stuff that we cover, we see people coming in quickly, topically, that aren't law nerds, saying awful shit about people. We're like, no, that's not what we do here. We don't talk about people that way. And that's how we are. And I think there's a shift, and we'll see if there's a shift online in the way people engage. I mean, the internet can be awful, and people can say awful things. And a lot of speech that people find objectionable is protected by the Constitution. But while platforms are private platforms still have rules that they are allowed to moderate and enforce. And that's a big conversation when we get to talking about the Onion and Section 230 and platforms and what we're allowed to do with platforms. So that's where we're at. I hope for transparency. I hope that the platforms are clear and make it clear when and why and how they do things. That's absolutely what I hope for. Stephanie asks, free speech rights are about the government not censoring you, not companies. Correct. It's about the government not restricting speech, which is why the license plate content gets so interesting. And the license plate content, because license plates are issued by the government, what that is. Private companies like YouTube are allowed to make their own rules. They're allowed to moderate content. They are allowed to moderate the rules of their platforms. But there's also a boundary that's difficult because they are also becoming almost a public square, because it's where people get their news. And so there's this tension with Section 230 that we will talk about with the Onion. There's this tension with Section 230 that when platforms remove people from a platform that or censor topics on a platform, there's no repercussion. Normally, if you go into a business and you're denied service, you can sue them. There's some repercussion, but that's not the same with internet providers and companies that fall under Section 230, like YouTube, like Twitter, like Facebook. So you can't sue them. They're protected by Section 230. So there ends up not being this repercussion. And that's where kind of the law tension push-pull is on how platforms are enforcing their rules. Are they enforcing their rules fairly? Are they enforcing them evenly? Are they enforcing them the same way against everyone or not? And that's where we see a lot of this conversation about Section 230. So we will see. It looks like a third strike. It sounds from everything that I've seen and everything that I know that Nick is appealing those strikes, and we will see. So Danielle said huge social media platforms are acting like privatized utilities almost. And that's really a question that goes back and forth with Section 230. Have they become utilities? And what is the boundary of that? And these are conversations I think we need to continue to have. What are the boundaries of that? And is there a way to make platforms more transparent in the way they enforce their rules? I don't know. So we'll see. All right. With that, that's the push-pull. That's the push-pull here. And I really don't like the massive coordinated efforts to try to take people down. It looks like this was a third strike. There were definitely people trying to claim that they had some part in taking down his channel. And that's where we're at. So we need to move on. Plan Your Spoons said, the paradox of tolerance, there needs to be a level of moderation for there to be inclusivity of communities that are marginalized. And that's where we absolutely moderate our space, because we are an inclusive space, and that's our choice. And I get to choose that. And I'm glad I get to choose that. I love the way we moderate this channel. I 100% stand by the rules that I've created and the community that we've created and the way that we engage, because spaces can get wild really fast. And I don't like the internet being a Thunderdome. It is. And I understand that that's when you get free speech, people will say whatever they want to say, but then you get the platform saying, these are the boundaries on this platform. The government can't do that because the government the government can't stop you from speaking, because the fear is that the government will stop you from speaking about the government. When the government acts, or when platforms act as a wing of the government, then we have or an arm of the government, I should say, then we have a whole other conversation. And that's hard. And that's a hard conversation. There's very hard conversations to have. So let us continue on, and we will go. So, have you considered branching out into life coaching? Not kidding. No, I have not. Look, I am still trying to figure out how to walk through being a person that is online and somewhat visible after not being online and not visible and just putting my head down and doing my work. I like explaining the law. I like making that accessible to everyone. I am also, a neurodivergent creator. It's something I talk about a lot. I've been well familiar with being in spaces that are not comfortable for me, spaces that aren't welcoming for me, spaces that have been a fight for me. So I have some empathy on spaces that feel uncomfortable. I don't want a space that feels uncomfortable. Anyone who wants to talk about the law and have a conversation is welcome here. Anyone who's welcoming is welcome here. But that also goes with you do you. I'm not going to tell somebody how to live their life. What I am going to tell you is, if you come into this space, just like if you came into my home or were friends with my kids, I would ask you to be kind. And I would ask you to be welcoming. And I would ask you to taste your words before you spit them at somebody. But I can't and don't want to monitor the entire internet. I just want to monitor my little space of the internet so we can have an amazing community and have conversations. That's all. That's what I want to do. And I think it leads a shining example. It's why I don't engage and fight with people on Twitter. It's why I will have a conversation if somebody wants to have a conversation, but I will not just fight with people, because the Twitter is not a place for nuance. And it's why I engage the way I engage around the internet. because that's what works best for me. So anyway, that's where we're at. Candy Lane said, been using tastier words at home with my kids. And I think it's a push-pull between understanding context and circumstance and appropriateness of places and being able to express yourself and being able to have a conversation. Conversations are so valuable, but I don't think you can have an equal conversation when people don't feel physically or emotionally safe to have a conversation. How can you really learn anything when you're like, this person's just going to jump on me and attack me for anything I say? That you can't express yourself in that way, and we don't learn anything in that way. And so we just try to make it open to genuinely ask a question, like something as simple to me as, what's the difference between a pro per or pro se? No one's going to give you a hard time about asking a question, or what's, the difference between sovereign citizen and this and that. No one's going to give you a hard time. But if you come into my comments and start leaving comments about like Angelina Jolie's body or weight or what she should or shouldn't eat, you're going to get yeeted, because it's not a question. It's just trying to tear someone down based on their body, and we're not doing that. So that's where we're at. Wolf Rebel said, boundaries for engagement to be respectful are perfectly reasonable, and conversation with people yelling and talking over each other are counterproductive. I agree, because then you just want to win. It literally triggers your brain into just wanting to win, because then you're under attack, and then you're like bumped into fight or flight. And the internet does this to us so much, where we're bumped into fight or flight, where we're just like, I feel like I'm being attacked, probably because you are being attacked on the internet. I feel like I'm being attacked. And when I feel like I'm being attacked, I need to fight or run. And that's not a place to have a conversation from. That's not a place to come to understanding. That's not a place to learn about people. That's not a place to expand how you see the world or how they see the world. That's not a place to come to genuine understanding, because it's not coming from a place of empathy and compassion. It's coming from fight or flight. And when we're in that mode, we can't learn, we can't compromise, we can't grow. And you just end up with this all the time. And then we get nowhere. And then we get absolutely nowhere. So Noor Jahan said, I love how supportive this channel is. I can be trans and Muslim and disabled and still feel loved here, because you are still loved here. And there's no reason that you shouldn't be. I love the way you engage around the internet. Thank you. It's not always easy. It is, again, there's times when I am triggered into fight or flight, and I'm like, I want to fight you with my words. And I'm like, no, if somebody wants to have a conversation, we have a conversation, but I'm not just going to fight. I don't like having things demanded of me. There's times people are like, have you talked about this? When it's like, are we going to cover this? Perfectly fine. But when I feel demanded upon, I get very like, why are you telling me what to do? It's the internet. 4D man, Twitter's not a place for nuance. It's true, because people read text through their own lens. So if somebody means something genuine, somebody else might read it as snarky, and it's just... True said, Emily, your channel is authentic, safe, and informative. What else can we ask for? Thanks for fixing my membership. You're welcome. Thank you. And we are trying. And that's why we love you, Emily. But thinking about life coach as a retirement thing wouldn't be bad. I don't think I have any qualifications to do that. Life's a journey. This is really what it's about. It's not just about having dignity. It's about treating everyone with dignity, because it's what humans deserve. We all deserve to be treated with dignity, and empathy. And that's what it is. That Sarah said, just got the Twitter notification. That was my bad. Runkle of the Bailey. Hello, folks. Speaking of people who engage compassionately around the internet. So this is irate overlord. This is always hard for me. I have 2 ears and 1 mouth, use the ears twice as much. Oh, ADHD interrupter here. And it's always hard, because there's times I'm like, ooh, if I don't say this, I will forget it. And I've meant to say it. So it also, the thing that's hard about engaging genuinely on the internet too, is that it requires setting boundaries. And setting boundaries is something a lot of us are not taught, and something a lot of us aren't encouraged to do. And something that the internet is still so new. God, I feel so fucking old saying shit like this. Damn it. The internet is still so new in our experience as humans that we are still finding ways to set boundaries. And it's a really difficult thing. And I don't think there's any good way to learn other than to try to learn by doing. But the internet also has a very long memory and not a lot of tolerance for people being human. So then people are afraid to try and to try to set boundaries and to try to find ways to engage. And then it becomes, like a game of pitfall where you're trying not to fall into the pits as you're trying to figure out how to engage and have conversations. And I think our values as a society are continuing to shift towards more inclusivity, which I think is amazing. But that bumps up against traditional structures of power and how things were done and back in my day and all of that. And we are continuing to evolve as a society very, very quickly. Human evolution used to be very, very slow. And I think we're all trying to find our way in that. And I want to find a way to do that with compassion, with empathy, with boundaries. Will I always get it right? Absolutely not. I stream on the internet for a living and say lots of words. Will I always say them well? No. But will I always try to do my absolute best? Yes. Will I always try? Absolutely. Will I always bring you into the conversation? Yes. And we do try. And that's, I think, all we can ask of people is that we try and we learn and we grow. And I see it in the chat when people are like, hey, what happened? Why is Nightbot mad? It's like, oh, caps. Caps are hard to read and they feel like yelling. So Nightbot gets cranky. Oh, wait, we're only allowed to do, I think Nightbot has a cutoff of like 4 or 5 emojis instead of like 12. I love an excited 12 emoji, but we cut it down so it doesn't just spam the chat. And just figuring out those rules and kind of guidance on how to get along. And then we all know. It's so nice when we all know what the rules are. It's like when you're in a classroom, it's like, this is how we engage. Great. We all know. We're all on the same footing. We're all equal here. And we get to have the same footing and have conversations because we all know where the boundaries are. And that's one of the things that makes it so special to have this community on the internet. And I love that. Sue, speaking of boundaries, I love you and appreciate your heart and your boundaries. And setting boundaries in real life are hard. Setting boundary on the internet's hard. So it's hard. Let's see. I become super overwhelmed when talking turns to arguing or name calling. Me too. I don't like it either. And I worked as an attorney and it caused me complete adrenal fatigue and burnout. I didn't like it either. Fighting in court is a bit different because, again, when you're in court, there are rules and boundaries. There are rules of engagement and there's a judge. There's like literally a referee. So you know the rules. It's like playing sports. You know what the rules are. You know what the fouls are. You know there's a referee. But in conversation on the internet, that doesn't exist. And that makes it difficult to set your own boundaries and to set your own rules. And that's hard. But we just keep trying. We just keep trying. So, thank you for the safe space. It's appreciated so much. It's what I like. I don't think I could stream like this. I wouldn't want to stream to a community that wasn't this. So, yep. Tonya, I think I pronounced that right. If I didn't, I apologize. And this is exactly why I follow your channel. It's the only place I can find thoughtful discourse. And that's because, and again, thoughtful discourse requires some rules. It's why when you even see, I don't talk about politics on this channel. I like to just cover the law. And I definitely don't have the background anymore into modern politics because it's all changed so much. But when you have political debates, there's still a moderator. That job as moderator, as you watch the debates years over years, has gotten harder and harder because people just start yelling over the moderator. But it's why there were moderators for those conversations, to make sure that even when things got heated or emotionally charged, that there was somebody who was creating rules and saying, you have this much time and then you have this much time. And then we don't expect that, or we don't have that on the internet and then expect things not to devolve. And devolving is hard. And I've talked way longer than I anticipated to about the internet, compassion, communities, and we get to choose. And I think, again, we can expect, and I think we should expect transparency from our platforms about what their rules are and how and why they enforce them and what they mean anyway. I think that's a fair expectation. And then those on the platforms to follow the rules that are set, That's a fair expectation, and that's a fair boundary. And then to let creators set their own communities and find a community that you like or don't like. And you can find lots of different communities that you like or don't like. And I think it's fair to say, hey, this isn't for me. I'm going to just so, and that's fair too. All right, let us continue on. I'm going to answer a few questions and then, oh, my nose is running. And then we're going to move. Let's see. Emily, are you going to cover Brad and Angelina? Yes, on the podcast. And then they're still in pretrial. I don't know if that's going to go to trial, but if it does, I will. But that'll be on the podcast, I think, next week. The Clever Biatch said, I missed you at Vid Summit. I missed being at Vid Summit so much. The amount of FOMO I feel because I was sick. So hard. So hard. So hard. And Merrick, I see your question. I'm going to save this for Q&A. So I will save that for Q&A as we get through our topics because I've talked a ton this morning. Just Me said, I believe that we should love everyone, and I do. It's just that I love some people from afar, as far as possible. And I think that's fair too. Healthy boundaries, and all in the internet needs healthy boundaries. I'm going to save this for questions. I'm just letting you guys know. We'll get to Q&A. So Replay Crew, I didn't even tell you how much I loved you. I loved you, Replay Crew. Everything will be timestamped down below. George is just hanging out, doing his, yeah, I'm talking about you, George. I know. Hi, buddy. George is just doing his Georgie things. You can tell when he's up and saying hello that he has no white on him. He is the full ginger snap. Fred is orange and white. All right. Let us get in. We will get to questions at the end. Do not worry. We are going to talk about topics. Am I ready to talk about topics? Sure. Am I set up to share my screen? No. We're professionals here. We are professionals. Wop, 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 wop. So what should we talk about first? What do I have first on the docket? Cardi B and Tasha K is what I have on the docket first, and then we'll talk about Rust. Does that work for all of us? Good. That works for me too. Let me pull up the, we're going to go into the law-related gossip first, because I think that's what it is, because I still haven't seen the court filing. Maybe we'll find it in our reading today that they're talking about. So I think we're going to go through the law. We don't talk about gossip much. But when it's related to our cases, sometimes, which is what's going to bring us to Radar Online this morning, once I get my screen share sorted like a professional. Not at all. You guys are right. I didn't swoop. Chat is bae. Chat lets me know. Swoop, 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 swoop. I will. I'm not ready yet, so I can't swoop just yet. Radar Online seems to be the first one who covered this story, and then Yahoo, I think, just covered what Radar Online said. It's always so hard to find the source material. It's like, who's covering what? All right. Let's talk. Let's swoop. We're going to talk Cardi B and Tasha K. For those of you that did not follow along with the Cardi B Tasha K case, here's where we're at. Cardi B sued Tasha K. Tasha K is a YouTube creator, online personality. Cardi B went to trial over defamation for things Tasha K said. Cardi B won. She won a $3+ million judgment after a jury verdict. It's one of those things where we don't see, and I think we're going to see more. This is my hypothesis, that in the age of shifting tolerance for things online, where reputation matters so much, where things people say can have real world impacts on jobs, on income, on everything. Truly, we're going to see more celebrities taking the avenue of court to protect themselves, and not just protect themselves, but because it's the only way they get coverage of, hey, this isn't true. We saw it with Nike over the Satan shoes. I think we got to see, Nike try to say we didn't make these shoes with mischief, but Twitter still was like, hey, Nike, fuck you in these shoes. And Nike's like, bro, we didn't make the shoes. The shoes are being made by somebody else. And so Nike sued. And then the media picked up Nike suing over the shoes. And then the internet went, oh, maybe Nike didn't make the shoes. And then the lawsuit settled in like a week. But that's the only way Nike's side of the story got covered. And I think we're going to see that more and more with celebrities. We just covered it with 50 Cent. We've seen it with Cardi B. We're seeing it with, Todd Chrisley suing a YouTuber. We've seen it with Tati Westbrook suing a YouTuber. We saw it in Amber Heard, Johnny Depp, defamation, reputation, and I think wanting the media to cover the other side of the story and not just the gossip. It's a hard thing for celebrities. I don't know how you deal with the detriment things being said online that are defamatory can cause without going to court, because that's when it gets covered. And I think we're going to see more and more and more celebrity lawsuits. I really do. And until the media starts covering kind of like, hey, this is an allegation, and until we as a society stop like clickbaiting on every headline, because we're curious, we want to know the tea. I think that's what we're going to see. The rise of celebrity defamation cases. I think we're entering into a lot of people being litigious. Yes. And Nate versus Boozy. Absolutely. And I think it's the only way. Well, I think right now it is the most effective way to get stuff covered. So let us share a screen and talk about this, and I'll stop. I think we're going to, I think in the online culture, why won't my screen share that we're in, we're absolutely going to see more celebrity lawsuits. Why is my screen share being weird? Because they changed the name of screen share to present screen. Crazy. All right. Cardi B discovers only $1,083 in bank account of blogger as she moves forward with collecting on $3 million judgment. We just covered this a little bit ago with the motions for, not garnishment, that's not the right word. The motions for attachment, that's also not the right word. We're going to get into them. Emily, pull up the motion and read the title. It'll make it easier for your brain. The supersedis bond motions. What's happening right now is that Cardi B is trying to force Tasha K to put up a bond of the amount that she will collect, and is trying to either protect her income or collect on her judgment, meaning putting a lien on her house, her income, her wages, whatever. So that's what is going on in court in context of this. So we know that Cardi B had sent requests for information and subpoenas to the bank, and this appears to be coming out of that. Cardi B attempts to collect on the $3 million owed. She's trying to get an attachment of property or a bond. We're going to talk about that in a minute. According to the court documents obtained by Radar Online, JP Morgan Chase Bank has informed Cardi that Tasha K and her company, KB Studios, only has $1,000 held in accounts. So they're going to try to get an attachment on the bank accounts, probably whatever accounts her Tasha K's income from Google goes into, which should be her business accounts, but who knows, her home, things like that. But they are trying to get an attachment on those things. The amount is a far cry from what's needed to satisfy the court judgment Cardi was awarded. Radar Online first confirmed Cardi recently started the collection process months after the jury sided with her. We're going to cover some of that today too. In 2019, Cardi sued Tasha K she made a series of YouTube videos, also on Instagram and Twitter. The blogger claimed Cardi had an STD, used hard drugs, worked as an escort in the past, among other things. And we've seen since then a stipulated permanent injunction that's like, you can't talk about this stuff ever. So let's see. The jury ended up awarding Cardi $1 million in general damages, $250K in medical expenses for a grand total of 1.25, and $1.5 million in punitive damages. Those are the punishment ones, and $1.3 million in attorney's fees. When you have to take a look at how much these cases cost, this is on the lower end for Cardi B of what these cases cost. When I say lower end, The 1.3 million is on the lower end, which is why people whose reputations are harmed that are not celebrities don't always take these things to trial. It's fucking expensive. Civil cases are fucking expensive. Tasha has filed an appeal to the judgment, which is pending. We've got that today too. If we want to look at the appellate brief, we're going to look at reporting about it before we go through the whole brief. If you want me to go through the whole brief, we will. Cardi started the process of collecting with the blogger, which included her firing off a letter to JP Morgan Chase, demanding they keep any funds owed by Tasha and be ready to turn them over. They might have done that too late if money has already been moved. The blogger has vehemently opposed Cardi seizing her bank accounts, arguing it's improper. Facts. Tasha argued the appeal should put a pause on collection efforts, and we're going to look at those filings today. IMS, I've seen word of this around the internet. I have not seen this live, but if Tasha K said in a live that she transferred $800K out of the country, it's going to complicate Tasha K, or it's going to complicate Cardi B going after it. It could have tax implications and things in the US when moving money out of the country. But if that did happen, there would be some trace of it with the courts. So not with the courts, sorry, with the bank. There would be some notation of it. So let us go through the response to the plaintiff's motion for the bond. So where we're at, Cardi B filed the motion for the bond or the motion to attach the property. Your Honor, let us get a lien on all of this property or have a bond put up. Tasha K has responded. I haven't covered that yet. We're doing that now. And then Cardi B filed the reply. So we get the opposition and reply together, which is always nice when we get to look at, they said this and then they said that. So we're going to look at those two motions, and then we can look really briefly at the underlying crux of the appeal before we move on to talk about Rust and Alec Baldwin. This case is fascinating, and I think I know it's not been as popular as some of the other topics that we cover, but I think it's a very interesting case to watch how this is all continuing to play out. And we're absolutely seeing kind of the full breadth of how this case plays out much faster than some of the other cases we've watched. This went to trial pretty quickly and came back with a jury verdict pretty quickly and is now going through the post-trial litigation quickly. Yeah, it's not done when the jury verdict comes down, which how many of you are just like, oh shit, you get a verdict and it doesn't stop, right? It doesn't stop. So even though Cardi B got $1.3 million in legal fees awarded by the jury, it's not over yet. They're still fighting over trying to get the money. So you've got the first part of the trial, which is winning liability and damages. And then you've got the whole second part trying to actually fucking collect those damages, which is still going to cost you legal fees. It's wild. 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 So let us, that's what I wanted to do. Get in here bigger. All right. Defendant's response to plaintiff's motion for a supersedes bond and request for a hearing. We would like a hearing. All right, let's see. Defendant Tasha K and her business through undersigned counsel submit this response. Great. Relevant facts and procedural history. We love a good facts section. On February 1st, 2017, this court entered a judgment in favor of plaintiff in the amount of $3,863,753.47. That's the exact amount. On March 17, 2022, defendants filed a timely notice of appeal to the United States Court of Appeals 11th Circuit and paid all costs of appeal. They did. On July 15th, the 11th Circuit of Appeals dismissed the appeal for lack of jurisdiction and informed the parties how to correct the outstanding jurisdictional concerns. Yeah, the appeal court said you filed it wrong. Go back and do it again. On July 19th, this court entered an amended final judgment in favor of plaintiff in the amount of $3,863,753.47. Wait, what was the other amount? I've already forgotten. That seems like the same. $3,863,753.47. $3,863,753.47. Same, right? I haven't transposed a number, have I? That looks like the same. Anyway, entered an amended final judgment on July 19th. Fine. July 29th, defendants filed a timely notice of appeal to the United States Court of Appeals for the 11th Circuit. Again, paid all costs up front. Well, what's the jurisdictional issue if it went to the 11th Circuit and it went to the 11th Circuit? That's a question I need to answer. I'm just making a note in my brain. On August 23rd, plaintiff filed a garnishment action against both defendants in the state court. However, that's where we need to go look. I bet that's where that filing's coming from, is the state court. Hold on. We're making a note. We're making a note. See? There we go. There we go. State court. We need to go look at the garnishment action. I've been just pulling the federal action. However, plaintiff failed to properly serve the defendants, which left them unaware of this pending garnishment action. We'll go take a look. August 29th, defendants filed appellant's opening brief in the United States Courts of Appeals for the 11th Circuit and timely submitted their appendix. On August 30th, plaintiff served the garnishment documents on Svetlana. I think that's right. Svetlana Payne of JP Morgan Chase Bank. However, plaintiff failed once again to properly serve defendants. So this is just happening. And there's the shade. They did not serve the defendants. On September 1st, plaintiff applied for a writ of execution against defendant and company. That was the first time defendants learned of plaintiff's clandestine. The clandestine attempts. The clandestine attempts to enforce a judgment, the execution of which had already been suspended for over a month. Why was it suspended? Oh, they're saying it's suspended by the appeal. Okay. On February 2nd, 2022, defendants filed a motion for stay pending appeal and a motion for denial of plaintiff's application for a writ of execution. Hey, we want to garnish your shit. On September 7th, plaintiff requested and was granted a 30-day extension to file the appellee's response brief. So that was last month, which is currently due October 28th. I'm making a note. Response brief. I'm putting it in my calendar. On September 16th, plaintiff filed a motion for a supersedis bond in the amount of $3,863,753.47 and a brief in response to defendant's motion in support. All right. That's a pretty thorough timeline. Thank you, counsel, for the fabulous facts section that really summarized all of the procedural history with the slimmest amount of shade, which, you know, lawsuits are allegations and shade, and we appreciate the slimmest amount of shade. It keeps all of us amused. The slimmest amount of shade about the clandestine attempts. You knew this was coming, though. Like, do you think that Tasha K's attorneys and Tasha K perhaps, and this is not a creator I follow well, so there's no way I can imagine what they are thinking. But do you think the attorneys and Tasha K were like, she won the judgment. She's not really going to care about enforcing it. Like, she's Cardi B. She has money. Does she care? Maybe they just thought that they wouldn't go through with trying to garnish and trying to attach. But Tasha K did go out publicly after the judgment and say, come at me, bro. I don't have any money. Good luck. Basically, good luck getting blood from a stone. And even if Cardi B was like, I don't know if we're going to go after this 100, after somebody's like, good luck, motherfucker, don't you think you'd just be like, oh, fine, it's on. It's on. It's on. Maybe. I don't know. Maybe that made it worse. Maybe it didn't. But I appreciate the modicum of shade. Argument. Although defendants recently submitted 2 motions explaining that in the case at bar, Georgia law governs proceedings concerning stays and bonds, plaintiff somehow managed to waste an entire brief citing inapplicable rules in case law. There's the more shade. There's the more shade. Plaintiff somehow managed to waste an entire brief citing inapplicable rules in case law in support of their request for a supersedis bond. Footnote 1. What does footnote 1 say? All right. Let's see. The following is a list of non-binding authorities plaintiff relied on for support. Hey, Your Honor, here's a list of all the wrong shit they said all at once. I've never seen somebody say so many wrong things all in a row. I'm going to get that quote wrong, but you know what I mean. You know what I mean with that. The following is a list of non-binding authorities. Ayers versus Harrison from the 11th Circuit. Wait, why is the 11th Circuit not binding on Georgia? Isn't the 11th Circuit Georgia? What? Okay. Steel LP versus JSW Steel USA, which is from the Fifth Circuit. Okay, not binding. Analyzing and applying Texas law. Fair. You're allowed to cite non-binding law. The court just doesn't have to apply it. But Horwich versus Diamond Aircraft is an 11th Circuit case analyzing and applying Florida law. Okay. Rowell versus Metro Life with a North District of Georgia case, federal question jurisdiction. I think that would probably be applicable. It's a Georgia case talking about federal question jurisdiction, but I guess, well, no, they're talking some about federal question jurisdiction because they're talking about which law applies for the collection actions. And what I mean by that is this is a Georgia case, but it's a federal case. And so the argument is which law applies for the collection action. So, let's see. Plaintiff mistakenly cites Federal Rule of Civil Procedure 62B to support the position that defendants, quote, are only entitled to a stay upon providing a supersedis bond. However, Federal Rule of Civil Procedure 62F controls here. Wrong subsection, yo. Because defendants paid the cost of appeal in the trial court at the time of their last two motions were filed, pursuant to Georgia law, they were entitled to a stay upon appeal without having to post a supersedis bond. So we talk a lot about the bond and what bond happened and Depp v. Heard and did a bond or did a bond not or blah, 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 blah. But here, what Tasha K is arguing is, hey, the law says that we get a stay, timeout, a pause on the collection action until we're done with the appeal. So you don't own me until the appeal's done. That's what they're arguing. It's not what Cardi B argued. So let's see. Therefore, they say plaintiff is incorrect in asserting the defendants had an automatic obligation to post a supersedis bond. The supersedis bond would be a bond in an amount that would make this pause. Let's see if I can summarize that even better. The argument is over whether or not the attachment can go forward, whether or not Cardi B can try to get to Tasha K's cash while the appeal is pending, or whether Tasha K has to put up a bond to pause that action, or whether or not the action is automatically paused, like you can't go after the cash because the appeal is pending. Hopefully that made sense in the way that I explained it. So Cardi B is like, no, you either have to let us move forward on collecting your money. Hey, dirty, baby, I got your money. Sorry. You either let me go forward on getting your money. I'm going to have to come up with more money songs. You either get to go forward on collecting the money, you post a bond to pause me from getting your money so that if the appeal doesn't go through, then the bond goes to me. Those are the two things. I get to go after your cash, you post a bond. Tasha K is saying, negative Ghost Rider, the pattern is full. I don't have to post a bond because I already paid for the appeal and that counts. This is similar to what we saw going on in the Depp v. Heard case. Amber Heard posted the fees for the appeal, but did not post the suspension bond, which would be the amount of the judgment and interest, so that Depp couldn't go after enforcing a judgment. So could we theoretically see Depp go through all of the shit Cardi B's going through now and do the most and try to attach and garnish funds and put liens on properties and stuff? Could. There's nothing to stop it. That's the same argument that's going on here. Hopefully that helped. Did that make sense? Chat, did that make sense? Did I make sense? I'm still getting over being sick. So let me know. Hopefully it did. They go on to say, furthermore, plaintiff wrongly claimed that defendants have failed to meet their burden of demonstrating the necessity for a reduction or a complete waiver of the bond amount under Georgia law unless a motion by appellee is filed. The notice of appeal, quote, shall serve as supersedis upon payment of all costs in the trial court by the appellant, and it shall not be necessary that a supersedis bond or other form of security be filed. So they're saying under Georgia law, once you pay for the appeal, you don't have to do anymore. It's important to remember at the time defendants filed their motion to stay, plaintiff had not yet moved this court for a supersedis bond. Okay. In fact, defendants had absolutely no reason to anticipate such a request when their first notice of appeal was filed nearly 7 months ago on March 17th. Plaintiff never moved for a supersedis bond until now. That's true, they didn't. Given that plaintiff has requested a supersedis bond, quote, the trial court shall require a bond to be given in the amount within his discretion.
All right.
When determining the bond amount, this court is authorized to consider whether the defendant's present financial condition is such that the posting of a full bond would impose an undue financial burden. Quoting, look, man, here's the thing, though. Do you see what my problem is? They did a whole footnote calling out Cardi B's attorneys for citing non-binding law. Like, yo. You didn't do the thing. But then they're citing Fifth Circuit case law. Don't shade somebody in the footnotes for citing Fifth Circuit cases here and then do the same thing. What? Maybe just. This court, after notice and hearing, that's why they're asking, hearing, can lower the bond if the court determines the defendants have shown good cause for fixing the lower amount. And then these are Georgia Court of Appeals cases. Alternatively, after conducting a hearing, this court can order defendants to give another form of security in lieu of the supersedis bond. Conclusion: for the foregoing reasons, defendants request that the court withhold ruling on the motion for the bond until after the hearing. So they're asking for a hearing. That the court schedule a bond hearing. Well, that should have been the first thing. That the court schedule a bond hearing and allow both parties the opportunity to present pertinent testimony and evidence to support their positions. Then it should be that the court withhold ruling until after the hearing that they've just set, and that the court stay the execution of final judgment until a ruling regarding the bond has been reached. Because Cardi B is asking not just for the bond, they're asking for an execution of judgment. Execution meaning they're allowed to go forward and do it. All right, what else? That was served. All right, let's go to the reply to the opposition. It's pretty short. And so Tasha K's position is hold a hearing. I think the argument is to reduce the amount, and we don't have to post a bond, but please hold a hearing. What's interesting, you know what's interesting? They didn't ask that the court just deny it. They didn't ask that the court just deny it. Normally what you'll see is you'll see the attorneys say, look, deny their motion. Just deny it. This is what I thought they would have argued. We already posted everything we need for appeal. Under the law, we're not obligated to do anything else. Just deny this motion, Your Honor. Obviously, we're all good. The law says we did what we needed to do. Deny. But they didn't ask for that here. They asked for a hearing. The only purpose of a hearing would be to reduce the amount of the bond. So are they conceding in their conclusion that a bond is appropriate? That's my question. Is that a concession by not saying defendant requests the following, deny the motion, is not here anywhere? The court doesn't rule. Pause. Don't rule yet, Your Honor. Don't deny it. Just hold a hearing. But they never say, just deny the motion. I wonder if that's a concession, because they argue up here, they argue that they don't have to file a bond. Did I read that wrong? Have I lost my mind? Did I read that wrong? Let's see. I need to go back and see what they argued. They argue it right here. Under Georgia law, unless a motion by appellee is filed, which happened, the notice of appeal shall serve as the bond. An appellant, it's not necessary that a supersedis bond or any other form of security be entered. It's important to remember at the time the defendants filed their motion to stay, plaintiffs had not yet moved this court for a bond. So I guess they are conceding the point that once a bond's requested, it can be required. Defendant had no reason to anticipate such a request when their first notice of appeal was filed 7 months ago. Okay. So under Georgia law, their argument is there's no bond required until it's asked for. It's been asked for, but please don't order it yet. We want it a reduced amount. All right. We figured it all out in my brain. We figured it all out. Hopefully I made it clear to y'all too. You're like, yes, Emily, clear as mud right now. Clear as mud. All right. Let's see what the reply is. I think we've sorted through that motion sufficiently. Plaintiff's reply brief in support of the bond. Despite acknowledging that they bear the burden of demonstrating why this court should deviate from the unusual requirement of a full security supersedes bond, citing that case law, defendants still have made no attempt whatsoever to meet their burden. Instead, they request that this court hold an evidentiary hearing on the amount of the bond requirement. However, defendants have not established that a hearing is necessary. Hey, Your Honor, why do we need to have a hearing? Why is this a burden? It's true. They did not state anywhere that it was a burden. They stated if it was a burden, then the court could reduce the amount, but they never said, and it is a burden, here's why. There are a number of factors that courts have considered when evaluating the amount of a bond requirement, including the judgment debtor's ability to pay. Footnote 1. The Dillon factors have been applied by district courts in this circuit and elsewhere, citing case law. Defendants have not argued that any factors favoring reducing or waiving the bond requirement. That's true. They have also not submitted any affidavits or other evidence to even make a threshold showing that defendants are incapable of paying a full security bond, or that the requirement is otherwise, or that the judgment is otherwise secure. Fair. And then they cite case law saying holding evidentiary hearing only after the judgment debtor had submitted affidavits. So they're arguing that the threshold hasn't been made. So why are we having a hearing? You haven't even met the threshold to show that it's necessary. Without any evidence submitted by defendants for this court to evaluate for plaintiff to contest, an evidentiary hearing serves no purpose and would simply add additional delay. Footnote 2, defendant's failure to meet their burden prevents plaintiff from determining what post-judgment discovery may be necessary in advance of a hearing. Let's see. And that is citing the case law. Oh, and we're out. Because defendants have not even attempted to satisfy their courting, this court should grant the motion without a hearing and require the bond in full amount of the judgment. So they're saying, just give us the $3 million bond. Well, $3.8 million bond. They didn't even weigh the factors. Who knew there were factors? We didn't know there were factors in the opposition. The opposition didn't mention a single factor. They could have said, she doesn't have the money. Those are the factors. She can't pay for her appeal if she posts this bond. Very interesting. Let's look at the appeal real quick, and or look at the reporting regarding the appeal real quick. Let's go to the headlines, if you will. And then if we want to do a deep dive into the brief, we will another day, because I do want to move on to the Rust settlement. And then I do want to look a little bit at Section 230 and the Onion. So we do have quite a lot to discuss today. Let's talk about this appeal filed by Tasha K. Tasha K filed the appellate brief, I think on August 30th. So that appellate brief has been in for about a month. So if we need to get to it, we absolutely will. But we're looking at some reporting from Law 360, which, you know, I like Law 360 quite a lot. YouTuber tells 11th Circuit Cardi B libel trial was lopsided. The headline has me in. So let's take a look at what they have to say. A Georgia-based YouTuber found to have defamed rapper Cardi B has asked the 11th Circuit to reverse her $3.8 million loss, saying an Atlanta jury trial was lopsided because the district court excluded evidence about the celebrity's character. Tasha K and her company asked for a new trial in a brief Monday. A jury found in January at the end of a 2-week trial that Tasha K had maliciously slandered the rapper whose real name, and I never pronounce Cardi B's name correctly. Belcalis? I think I always get it wrong. So I just stick with Cardi B because I always get it wrong. And then I'm embarrassed that I get it wrong. Tasha K said she should have been allowed to present evidence at trial that Cardi B had allegedly admitted her quote unquote gang membership and threatened other quote unquote bloggers when she didn't like how she was being portrayed. The jury should also have been allowed to hear about Cardi B's alleged quote hateful comments to strangers on social media. Interesting. However, what I do know from the coverage I've done of this case is some of the things Tasha K is talking about were parts of counterclaims that got thrown out by the court. So some of that, oh, Miss Lee, thank you. Bell Collies. Thank you. I appreciate that. We got it. Thanks, chat. Chat is wise. So with that, some of that came because Tasha K filed counterclaims against Cardi B, and those counterclaims were then dismissed. So some of this, not all evidence of what people do is relevant to all things. And so far, none of this seems relevant to the defamation at hand because this is not the subject of the defamation. Just my initial thoughts. It goes on to say that, quote, the district court's erroneous exclusion of plaintiff's character resulted in a very lopsided presentation of evidence to the jury because the jury did not get to learn the type of conduct plaintiff engages in or who the plaintiff truly is as a person. The jury returned a general verdict for plaintiff against both defendants. I will just say on the other side of that, whether Cardi B says mean shit to people on the internet is not super relevant to whether or not she has an STD or has engaged in criminal activity, unless it's specifically relating the criminal activity that was found to be defamatory. Just saying. Cardi B sued Tasha K in March 2019 over YouTube videos and social media posts that Tasha K and her company published since September 2018. The content alleged that Cardi B was a prostitute who used illegal drugs, cocaine and Molly, that she had oral herpes or cold sores as well as HPV, and that she had cheated on her husband and publicly performed a lewd sex act with a beer bottle. I believe the court called it a debasing sex act with a beer bottle multiple times. And this is part of what's relevant to the defamation. Cardi B saying shit on Twitter, unless it relates to those things we just talked about, isn't going to be relevant. Cardi B, who testified during trial, denied all the allegations and told jurors that Tasha K's conduct caused her to become severely depressed and contemplate self-harm. YouTube hates that word, so we're going to go with that. She explained that Tasha K had disregarded and publicly ridiculed 3 cease and desist letters asking for the content to be removed. What was interesting to me about this trial is how, from my perception, I think Cardi B was very vulnerable in her testimony. We covered her testimony through reporting of others, and how even someone who is a very large celebrity, I think Cardi B is a very, we go into the top realm of famous celebrities, that people saying things about her that weren't true were this damaging. And again, when we talk about the internet being a mean place, no one, I don't think, is exempt from that being hurtful and from that really, really causing damage to people. And I think we saw this as I sidebar real quick. We're going to sidebar real quick. We saw some of this addressed in the D'Amelio show on Hulu. I don't think the D'Amelio show was epic, but we saw them really address the hard side of social media. And we're even seeing it in the Kardashians show, where they are talking about the hard side of social media. And it's interesting to see a celebrity on the level of a Cardi B or celebrities on the levels of the Kardashians talk about how internet harassment personally impacts them. And it's a really interesting thing to see. And I think it's, as we talked about the internet being mean earlier, I don't know. There's a reckoning. I think all of this is going to come to a head with how people engage in the internet. And I think, well, other countries, not the US, but other countries have laws that are much broader when it comes to cyber harassment. And at some point, there's going to have to be some kind of reckoning between cyber harassment and free speech and where those boundaries are. And I think that our law catches up very, very slowly, but we're going to have to see it because it clearly causes people damage. And I don't know how you are a celebrity and try to live your life as a celebrity without this being damaging, and where those boundaries are. And that's why I think we're going to keep seeing more and more celebrity lawsuits to shut this kind of stuff down. And where we have conversations about cyber harassment and cyber bullying when we see it impacting adults clearly, but also where it impacts teens. And I think those are big questions. All right, we should keep going. But I think these are conversations we need to keep having about where are the boundaries, and where are the, I think, who do you sue? Because you can't sue the platforms. Do you sue the people that are saying it? Do you sue all of the people that are saying it? How do you sue all the people that are saying it? And this never goes away. I mean, the reporting on this case, the allegations that were found to be defamatory are never gone. And where are the boundaries of that? I don't know. Worthwhile conversations to have. We're going to keep having them in the context of lawsuits. But I do think that Cardi B was really transparent in her testimony in talking about how difficult these defamatory statements were for her to deal with. The jury found Tasha K and her company jointly and severally liable on all counts of defamation, invasion of privacy through portrayal in a false light, which is adjacent to defamation, intentional infliction of emotional distress under Georgia law, so the IIED. And then we talked about the damages earlier that add up to the 3.8 whatever million. The U.S. District Judge William M. Ray II also permanently barred Tasha K and her company from publishing or republishing the statements at issue after the YouTuber agreed to remove the relevant content following a verdict. That was the stipulated permanent injunction. Tasha K told the 11th Circuit that Cardi B had failed to prove the statements were published with actual malice. Didn't she testify that she knew some of the things were false, though? Is my memory failing me? Because I think she testified that she knew some of the statements were false, and I think it's going to be hard to argue that she didn't know there was actual malice. Maybe we just wait. Chat, let me know what you think. Maybe we just wait until we get the response, and then we do an episode going over both of these and covering both of these. Maybe that's fair. So maybe we just do them together, because I think she admitted some of that on the stand, if memory serves. The YouTuber said she reasonably relied on comments that other people had made publicly about the celebrity, including a woman who used to work with Cardi B in a New York strip club and the rapper's own father-in-law. We're going to have to go through this appellate brief. Tasha K also pointed to public comments that Cardi B had made on social media, as well as the rapper's song lyrics, which the YouTuber claimed backed up her statements, which is a decent argument. If you're saying, well, I'm just basing it on her lyrics, she's saying those are real to life. She also cited photos of Tasha K and a video from a porn website of a woman who looked like the rapper in support of her comments. Oh, God. Are those submitted as exhibits to the appellate court? Oh, my. Oh, my. Oh my. Okay, appellate judges, buckle up for the internet. Quote, plaintiff admitted that she referred to herself as a quote unquote stripper hoe in the videos she posted on social media, Tasha K said in her appellate brief. Plaintiff admitted in an interview with Rolling Stone magazine that plaintiff used Molly to boost her confidence when plaintiff was a stripper. Tasha K argued that she did not direct the statements at Cardi B, but instead to her audience, which defeated the IIED claim. That's interesting. I'm interested to see the whole breadth of that argument, saying, well, I wasn't saying it to her. I wasn't trying to hurt her feelings. I was just trying to tell my audience, really, so that they would click on my videos and watch, I guess. The YouTuber said the jury should have been instructed to identify which of the 6 statements at issue were relied upon in their determination. That's also an interesting argument, because we saw so clearly in Depp v. Heard the way that the juries went through each and every statement. It wasn't quite the same here. She said Cardi B's testimony that the statements were false was not enough to support the judgment. Quote, the defendants presented a plethora of evidence showing the origin of each of the 6 statements and proving the defendants did not act with actual malice. Because the evidence showed that defendants did not act with a reckless disregard for the truth, plaintiffs should not have recovered damages for defamation or false light invasion of privacy. Tasha K argued that under Georgia law, the same statements cannot be used as a basis for both defamation and invasion of privacy by portrayal in a false light. Oh, that'll be interesting. That's an interesting legal argument that they can't find for both. I'm interested to see what case law supports that. And therefore, the jury's general verdict was not proper. She also said that IIED cannot proceed on its own. Quote, being that this court cannot determine whether the verdict was entered upon a proper basis, the verdict cannot stand. Additionally, because the jury erroneously found the defendants liable for both defamation and the invasion of privacy false light, this court cannot determine the underlying tort theory upon which the jury based its award for damages. Those are some very interesting legal arguments, which is why it'll be interesting, I think, to cover this brief with the response, because then we'll see the case law on both sides. So that'll be interesting. Let's see. Tasha K said a failure to retract or correct the falsehood does not prove actual malice. Similarly, the fact that she personally dislikes Cardi B is not enough. That's facts. Malice does not mean just ill will or anger. Tasha K also pointed to Cardi B's success as evidence that the statements did not harm her reputation. You do have to prove harm. However, when it comes to the intentional infliction of emotional distress, you don't have to prove financial harm. And when it comes to statements of criminality, and in Georgia, statements regarding infidelity and STDs and communicable, I think it's all communicable diseases, count as defamation per se. And with defamation per se, you don't have to show monetary damages. You just have to show that it was said. So, it says, even failure to investigate does not itself establish bad faith. There was no evidence that any of Tasha K's stories about plaintiff were fabricated by Tasha K, a product of Tasha K's imagination based wholly on unverified anonymous call, or so inherently improbable that only a reckless person would have put them into circulation. There are some interesting legal theories that I will like to see fleshed out. I think the way that we're going to do this is wait until, it's just at the end of the month and we are traveling to BravoCon. Wait till the end of the month and cover both the briefs together. I think that's what we're going to do. Team, cheers. That's what we've decided. That's what we've decided. All right. Let us talk about the Rust settlement, shall we? We're going to look at news reporting amongst other things, and we're going to look at the docket of this. Let me pull up. There are a few different articles that we're going to just go through. Some of them might have some repetitive bits, but let me swoop. There are a lot of things going on with the Rust civil cases. These are not things going on with the criminal cases. And after we cover Rust, we will go to questions, and I will answer as many questions as I can. But the news broke yesterday, October 5th, that Alec Baldwin has settled with the family of the Rust cinematographer. I'm going to go through who all the parties are in the wrongful death suit, because I think this would be a global settlement. So who all the parties were in the suit. So we're going to look at the underlying wrongful death suit. We're going to look at the docket and what has happened in the case docket, even though some of the documents are sealed. Just knowing what's going on gives us some insight. And then we're going to look at the media reporting of the statement from Helena Hutchins's widower, Matthew Hutchins, the details of the settlement that have been publicly released. I don't think we will see other details of the settlement. A statement by the district attorney in Santa Fe, and then thoughts. So let us get to the underlying, let us get to the thing I don't have pulled up yet, because we are professionals. Because we're professionals here. What I want to pull up first is the wrongful death lawsuit, so we can look at all of the plaintiffs involved and all of the parties involved, because it's been a while since I covered this. This is all covered very heavily on this channel here on YouTube and on my podcast, The Emily Show. If you do not pay for YouTube Premium and like to listen to me in the background, as I know some of you do, you can do that easily on your favorite podcasting app with The Emily Show podcast. It's called The Emily Show. I've covered a lot of episodes about Rust. There's a playlist of the podcast if you just want to cover all the Rust stuff. So with that, I won't forget the Onion. We're going to go there too. We're just going to have a long episode today. It's been a while. We're just going to have a long episode today. All right, let's look at all the parties involved in this wrongful death suit, because this is not just involving Alec Baldwin. So this is the lawsuit that was filed on February 15th, 2022. Matthew Hutchins, individually, so him as a individual person, and on behalf of his son Andros Hutchins, a minor child, and Christina Martinez as the wrongful death representative for Helena Hutchins, who is the deceased. So there's three plaintiffs: the widower on behalf of himself, and then on behalf of his son, and then the wrongful death representative on behalf of Helena Hutchins and her estate. The plaintiffs are this massive paragraph: Alexander R. Baldwin III, Rust Movie Productions, LLC, Eldorado Pictures, Ryan Donnell Smith, Langley Allen Cheney, Thomasville Pictures, LLC, Nathan Klinger, Ryan Winterstein, Short Porch Pictures, LLC, Angel Ningham, I think I pronounced that properly, Brittany House Pictures, Matthew Del Piano, Cavalry Media Inc., Ryan Danette Smith, Gabrielle Pickle, Third Shift Media LLC, Sarah Zachary, Seth Kinney, PDQ Arm and Prop LLC, Hannah Gutierrez Reed, Dave Halls, Catherine Walters, Chris M.B. Sharp, Jennifer Lamb, Emily Slaverson, I think, and Streamline Global and Doze 1 through 100. Those are all of the different defendants. Those are all the entities sued. So when we're talking about all the entities sued, we're talking about Baldwin, his company, all of the production companies, the armorer, the AD, and others involved in production. We've seen a lot of these names over and over again, with regard to production and with regard to the other lawsuits regarding this death and incident on set. The complaints for wrongful death and loss of consortium, we went through this entire complaint already, but I just wanted to get back to how many plaintiffs, even though the headlines are "this settled with Baldwin," if this case is being dismissed, it will be dismissed with prejudice. All of the defendants would need to settle. So we will see when they dismiss this case if Baldwin and his company are dismissed or if everyone's dismissed. I can't imagine that they would do this without a global settlement, meaning everyone settled all causes of actions. It's done. It'll be dismissed with prejudice, and everyone will just go, well, forward in a very odd and interesting way. Let's talk about what's reporting about how this is moving forward in its settlement. Our first report comes from Deadline. Here, let me pop this into the chat so we can put it in the description. So we can do that. My nose is still just, I don't know. My nose is still struggling from being sick. Rust Movie Productions reaches settlement with Helena Hutchins' estate, filming to resume in January. Matthew Hutchins to executive produce. This headline is so wild to me. Rust Movie Productions reach settlement. That gives me, again, indication that every single defendant we just named is part of this settlement. This is a global settlement. Filming to resume in January. I'm sorry, what? Hutchins, Matthew Hutchins, the widower, to executive produce the movie. What? We should put a poll up in the chat. If they finish this movie and release it, do you have any interest in going to see it? We should put that in the chat. I want to know what you think. I think a poll is appropriate. Thank you, Miguelina, for putting up a poll. Because it just, it feels weird. It just feels weird. It feels weird. The emotional response is, ugh. What are we doing? So this is now an updated article. Oh, I should refresh this and see if it's been updated this morning because there have been multiple statements. All right, just making sure we're on the latest update. I love the way that Deadline makes it clear what's been updated when they update. Thank you. Rust Movie Productions LLC and its Rust star and producer Alec Baldwin have reached a settlement with the estate of slain cinematographer Helena Hutchins as part of the piece. Her husband, Matthew Hutchins, will executive produce Rust, which will return to production January 2023 with the original cast. So this only states one of the production companies, Rust Movie Productions LLC, and Baldwin. It doesn't list everyone else, but I imagine, again, everyone else will have to be involved. You can't just settle with two parties and then continue on against the others. Again, that's me speculating that there will be a global settlement. The Hutchins family had filed a wrongful death lawsuit in February over the shooting of Hutchins that occurred on the set of The Western on October 21st, 2021, when Baldwin discharged a prop gun after being informed by the production's assistant director, Dave Halls, that the weapon was quote unquote cold. Quote, "We have reached a settlement subject to court approval for our wrongful death case against the producers of Rust, including Alec Baldwin and Rust Movie Productions LLC. As part of that settlement, our case will be dismissed," Matthew Hutchins said Wednesday morning. So, Emily, keep reading. That's a global settlement. The filming of Rust, which I will now executive produce, will resume with all the original principal players on board in January 2023, Hutchins added, of the most confidential agreement. That's an interesting way to say that. But the rest of the agreement, we're not going to learn about. We're going to learn what they release publicly, and that's it. We're never going to see this. It will be sealed. It will be accepted by the court, and that's all. He says, "I have no interest in engaging in recriminations or attributions of blame to the producers or Mr. Baldwin. All of us believe that Helena's death was a terrible accident. I am grateful that the producers and the entertainment community have come together to pay tribute to Helena's final work." It still feels weird. It just feels weird. The culmination of weeks of negotiations, today's news comes as the final report of the Santa Fe Sheriff's Office investigation into Hutchins' death and what really went down at the Bonanza Creek Ranch location that terrible day is expected to be handed over soon to local district attorney Mary Carmick Altwies. Several Rust crew members, including armorer Hannah Gutierrez-Reeves, have already filed ongoing civil lawsuits of their own in New Mexico and California. We've covered all of them. However, Wednesday's agreement between the Hutchins family and Baldwin and other producers could shift the legal landscape for those civil cases and any possible criminal charges from the DA. I disagree a bit. We'll get to the DA's statement. I disagree a bit. And here's why. I just disagree that could shift the legal landscape for criminal charges, because her husband's feelings about not wanting to go through, blame, not wanting to go through attributions, not wanting to go through this anymore is completely understandable. Of course, her husband is dealing with unimaginable tragedy. Not wanting to go through a criminal case is completely fair, but the husband doesn't really have to go through a criminal case because the criminal case is going to be about what happened that day and he wasn't there. So the criminal case can proceed regardless of this settlement. Whether it shifts the pressure on the DA to charge Baldwin is worth having a conversation about because it may shift the public perception and pressure. Rust Movie Productions LLC, through its attorney, Melanie Spadone of Pillsbury, everybody, Shaw, Pittman, people, quote, "We are pleased that the parties came together to resolve this matter, which, subject to court approval, marks an important step forward in celebrating Helena's life and honoring her work." I'm sure they're all pleased. Most wrongful deaths settle. I'm sure they are pleased with that. Baldwin's attorney, Luke of Quinn Emanuel, added, quote, "Throughout this difficult process, everyone has maintained the specific desire to do what is best for Helena's son. I very, very much hope that is absolutely 100% true. We are grateful to everyone who contributed to the resolution of this tragic and painful situation. which indicates to me, this is me reading into this statement by the lawyers, that more than him becoming a executive producer on the film happened, that there are multiple people or entities that have contributed financially. That's how I read that. That there is a financial settlement separate and apart from the executive producer credit, separate and apart from the movie going forward. And I don't know if it's my place to feel weird about this going forward if her husband feels good about it going forward and feels like that's the way to honor her work. He obviously would know better than I would. It just feels odd. Like, I need more time with it to decide how I feel, because if he feels good about it, who am I to feel weird about it? But it feels weird. I need more time. He's probably had time to process this. This information just came to us yesterday. They've been talking about this, I'm sure, not just for weeks, but for longer than that. Since this was filed in February, I'm sure they've been talking about a potential settlement because they kept delaying the answers in this case, meaning they hadn't answered the litigation. They were delaying the answers, probably because they were in these conversations, and why answer it if it's going to settle? Later this morning, the Oscar-nominated actor of The Cooler added this on Instagram, quote, "We are pleased to announce today the settlement of the civil case filed on behalf of the family of cinematographer Helena Hutchins," well, filed by them. "Throughout this difficult process, everyone has maintained the specific desire to do what's best for Helena's son. We're grateful to everyone who contributed to the resolution of this tragic and painful situation." And then he posted the article that we are now reading. So we've gone very meta, looking at the Instagram post of the article that we are in fact reading. Joel Souza, the director of Rust, said, "Those of us who were lucky enough to have spent time with Helena knew her to be exceedingly talented, kind, creative, and a source of incredible positive energy. I only wish the world had gotten to know her under different circumstances, as it surely would have been through her amazing work. In my own attempts to heal, any decision to return to finish directing the film could only make sense for me if it was done with the involvement of Matt and the Hutchins family. Though certainly bittersweet, I am pleased that together we will now complete what Helena and I started. My every effort on this film will be devoted to honoring Helena's legacy and making her proud. It is a privilege to see this through on her behalf." Y'all, does it change your mind that the husband's on board and that the director's on board? I don't know. The Hutchins original lawsuit in February claimed that defendant Baldwin and the producers were aware of firearm safety issues that occurred on the set of Rust and did not take corrective actions. We've gone through the lawsuit. Last month, Deadline obtained a letter from the Santa Fe district attorney that they were seeking additional money to prosecute. I covered that on the podcast last week. Let's see. There is a statement from the DA that we need to find. So hold on. It's not in this one. Hopefully it's in the Law 360 reporting, because the DA put out a statement after all of this. Maybe, did Deadline put it in a separate statement? Let's see. We're going to look real quick. Make sure we've pulled up everything. Yep, it's in a separate article. Okay, fine. Let's look at the second article. I'm going to put this in the chat too, so that we can put it in the description so you guys can look at it, and then we'll go to the Law 360 reporting on it and see. Of course, it's in a separate article. All right. Alec Baldwin and Rust producers' wrongful death settlement won't impact criminal investigation, DA says. Final police report expected soon. The final police report is expected very soon, but once they get the final police report, then there will also need to be a charging decision. It's interesting to me that the DA felt the need to put out a statement the same day. Let's take a look. I want to know what you guys think about the DA choosing to put out a statement. It's so odd. All of this is literally all of this is so weird. It's so weird. Why does the DA need to put out a statement? Because there's a settlement in the wrongful death case. Like, wait a day. What? That's just my feel. That's just literally my gut feelings. The settlement Wednesday between Alec Baldwin and Rust producers with the family of slain cinematographer Helena Hutchins and the resurrection of the indie Western won't stop possible criminal charges, the Santa Fe district attorney says. Quote, all right, coffee, statement. Nose. Quote, the proposed settlement announced today in Matthew Hutchins' wrongful death case against Rust movie producers, including Alec Baldwin, in the death of Helena Hutchins, will have no impact on district attorneys on the district attorney's ongoing investigation and her ultimate decision whether to file criminal charges in the case, said Heather Brewer of the Office of the First Judicial District Attorney after the settlement was made public exclusively by Deadline. Quote, while civil suits are settled privately and often involve financial awards, criminal cases deal only in facts, Brewer added. If the facts and evidence warrant criminal charges under New Mexico law, then charges will be brought. No one is above the law. End quote. It goes on to say in the long-awaited report from the Santa Fe Sheriff's Office, yes, it's been almost a year since this happened. They still don't have the final report from the sheriffs. CEG last week's podcast, because I think it was last week's podcast that we talked about. Hopefully it was last week. Damn it. Now I need to know if it was last week's podcast. I think it was last week's podcast where I talked about it. Hold on. I'm recovering from being sick. The brain is not keeping up with me the way I would like it to. We're just getting there. Let's make sure it was, episode 163. Last week is Alec Baldwin facing criminal charges. That was the episode where I went through the DA's statement about what evidence was in and not in. It's up here on the YouTube as well. And went through what they said they had and went through the DA asking for additional funds to prosecute up to 4 individuals. But it's weird to me that the DA needed to make a statement yesterday, because it's known, I mean, maybe it isn't widely known, but it's known that this doesn't change criminal liability at all. Let's see. The long-awaited report from the Santa Fe Sheriff's Office is in its final stages and could be handed over to the DA as soon as next week, we hear. Probably from their PR company. I want to know. Somebody keep me in the loop. Tell me too. Look, I know you're telling Deadline. Just tell me too. I have a public email address. Just shoot me an email and let me know. I would like to know. Of course it's going to happen next week. You know why? Because I get on a plane next week. That's why it's going to happen next week. Does that, Emily, are you making this about yourself? No. Shit always happens when I get on a plane. I imagine that this will happen when I am traveling, because of course it will. But that doesn't mean charges will happen. But will the DA's office put out another PR statement saying we finally have the office report and have everybody counting down to when they're going to put this out? Please, Santa Fe DA's office, just for me. Look, we're getting awful close to it being the 1-year anniversary. Do not file charges on the 1-year anniversary of her death. It will feel like a gross PR stunt for attention. Please just not on the anniversary of her death. Maybe I feel too strongly about it, but please don't. That would just feel really icky. But the timing of the thing is lining up in that if they get the report next week, I could see them waiting a week or two to make a statement or to make charging decisions. I don't want to do that. Don't do that. Don't do that. Let me get back to this article. The long-awaited report from the Santa Fe office or Santa Fe Sheriff's Office is in its final stages and could be handed over to the DA as soon as next week. We're recording this on October 6th. However, in terms of optics, it will certainly be a challenge for the DA to aggressively pursue Baldwin, who fired the gun that killed Hutchins on October 21st, 2021, and fellow Rust producers, now that Hutchins' widower has not only come to a settlement with them, but will now serve as an executive producer on the film. Rust is set to start filming again in January 2023. As whispers of talks of a potential settlement between Baldwin and the Rust producers and the Hutchins family have circulated for weeks, the DA has been putting her own chess pieces in place for when that report lands on her desk. Last month, Deadline obtained a letter from the district attorney to the New Mexico Board of Finance requesting $635,000 to prosecute as many as 4 individuals with criminal and homicide charges related to the Rust tragedy. Again, that's what I talked about last week in the podcast. The DA said in her letter that, quote, one of the possible defendants is well-known movie actor Alec Baldwin, which rubbed the Oscar nominees' camp the wrong way. Yes, his attorneys were pissed and called the report premature. Yes, they did. Rust armorer Hannah Gutierrez Reed also has a problem with the way that Santa Fe is handling the tragic case. In August, she accused the cops of not asking the FBI to test any of the live rounds found on set for fingerprints or DNA. That would be a problem. That would be a problem. What? That would test the rounds that are recovered to see the other rounds that were taken out of the gun. Test them. Don't just fire them. Test them. Who put them in the gun? How do you know who put them in the gun if you don't test them? I have questions. Quote, "It is inconceivable that the sheriff would not seek answers to this fundamental question, and it raises a serious problem with the entire investigation. We have long sought this answer and will not give up in pursuing the truth to find it," the armorer's attorney, Jason Bowles, said in a statement. Baldwin, since his December interview with ABC News' George Stephanopoulos, has insisted on his innocence in the Rust tragedy, claiming he never pulled the trigger of the prop gun that fired and took Hutchinson's life. Though we've seen the FBI report indicate that that's not necessarily the case, but I agree with the outrage of the armorer. Who put the bullets in the gun is one of the most fundamental questions in this tragedy. The second one is, how did live rounds get onto set? Those are the two biggest questions we need answers. How did rounds get onto set that were live? And who put them in the gun? How do you not answer those questions if you're going to criminally prosecute somebody? How is that the most basic fundamental question? And if for some reason they couldn't test it, that should be in the reports, which we don't have. We're just going off of the lawyer's statements to deadline. That's all we got at the moment. All right. I don't think there are any other statements that we need because we found the DA's statement. So that is what's going on with the settlement in Rust. No, a civil settlement is not going to impact the criminal charges, but it can impact public perception. It can impact cooperation if cooperation is needed with Matthew Hutchins for the prosecution. And we just don't know enough to really make those evaluations. I made those evaluations in the prior episode of the Emily Show, where I go through the law in Santa Fe and talk about what could be charged. And if it should be charged or not charged is kind of one of the bigger questions. The question I personally want to see answered is, how did live rounds get onto set and how did they get into the gun? I think that's the most important question. We know how the gun got pointed at Helena Hutchins. We know somewhat how the gun went off, but how that gun ended up loaded and in someone's hand is the biggest question here. And if that fundamental question is not answered, how do they pursue a prosecution of anyone? Because how can you say that Alec Baldwin, potentially willfully discharged a loaded weapon if you can't prove he knew it was loaded? We've got a lot of questions here. And I think this one's going to be a hard one for prosecutors to parse, but they don't have the final reports yet. So maybe stop making statements that you're going to prosecute people when you don't have the final reports yet. You need the final reports to know if you're going to prosecute anybody. Because I think they're setting themselves up for failure, because now they've said we want to charge 4 people, possibly Baldwin. What if they can't charge Baldwin? What if the law, based on what Baldwin knows and the evidence they have, doesn't allow for charges? And they've already kind of told the public that they're going to charge. I think a lot of people will be fucking pissed. All right, let's end the poll. Miguelina, let's end the poll and let's move on and look at the Onion a little bit before we get to questions. So we're going to take a look at the poll and see what you guys think. But Lord Almighty, we need some fundamental questions answered. And the fundamental questions are, how did this happen? Up to the point that the gun got in Baldwin's hand, what the fuck happened? That's what I want to know. All right, let's look at your poll results. And this is the poll from the live stream. I'm probably going to clip this as an episode for the podcast just to update everyone on the podcast on this. If they finish the Rust movie and release it, will you watch it? 88% no, 11% yes. Poll complete with over 1,800 votes. Based on the amount of all of you that voted, go ahead and do the YouTube-y things, the likey, thumbs up-y things. We need to talk about this. We need to talk about parody and Section 230 and platforms. We need to have a conversation. Let's swoop and talk about platforms. We've been talking about platform transparency already this morning. And this is platform transparency, parody, the Onion, and the Supreme Court. We are starting with the article from Law 360 because it gives a good background. And why do I like their reporting so much? A lot of their reporters are also lawyers. The Onion calls for parody protections in high court brief. This is a formal brief filed with the Supreme Court. We're going to look at the brief itself. Look, I'm all about a lol. I'm not mad about it. I'm not mad about a little bit of an LOL. Not mad. Not mad. Sometimes we take ourselves too seriously in law. Yes, there should be decorum, but I'm not mad at an LOL. Let's look at the reporting and then look at the brief. The Sixth Circuit put itself on the wrong side of Mark Twain by granting qualified immunity to police officers who arrested an Ohio man for creating a fake Facebook page that mocked his local police department. Satirical newspaper The Onion said in an amicus brief to the United States Supreme Court on Monday. That's a lot of a sentence. In a brief that blends history and legal analysis with The Onion's trademark absurdity, the publication said that the Sixth Circuit's April ruling in favor of the city of Parma, Ohio, wrongfully allows parodyists to be prosecuted for telling a joke with a straight face. The brief devolves into, etymology. Damn it. I'm going to say that wrong. Etymology. Etymology. Yep. You get to see the dyslexia work in real time, friends. I think I've pronounced that completely improperly. Hold on. We're going to the dictionary.com definition because I just can't. We're going to try the pronunciation guide. Let's see if we can get it. Oh, darn it. Sorry, y'all. I have to know. Etymology. See? That we're just going to start doing pronunciation guides for Emily because A, I'm too sick to work out my brain at the moment, and B, I'm terrible at phonemic awareness. So, the history of a linguistic form. Great. Let's continue. Now that I can pronounce etymology properly. Thank you, dictionary. Not to be confused. Vulcans said, as you were trying to pronounce it, I completely forgot how to pronounce it myself. Same. I love the history of words and how words came to be. I find it fascinating, but my brain stopped. So there we go. The brief that devolves into etymology cites Horace and Jonathan Swift and also openly mocks the federal judiciary as total Latin dorks who would be impressed by the newspaper's Latin motto, tu sultus es, you are dumb. The media company describes itself as having a readership of 4.3 trillion and boasts that it's, quote, the single most powerful and influential organization in human history, noting its serious, quote, self-serving interest in preventing political authorities from imprisoning humorists. Okay. Though it doesn't defend the quality or taste of the humor on display in the fake Facebook page at issue, The Onion has taken a stand for the right of the Ohio resident Novak to have made the page without retaliation from the police. This becomes a difficult issue because it is dealing with police and where impersonation, because impersonation of an officer is a crime, it's different impersonating officers than impersonating others for the purpose of parody, which is why this is actually coming before the Supreme Court. But when you're looking at somebody who was jailed, indicted, and tried for, and then acquitted of disrupting or impairing police function by creating the fake page, he subsequently sued the officers who carried out his arrest in the city for a number of claims, including retaliation and violation of his First Amendment rights and arrest without probable cause. He was jailed over the parody Facebook page. Novak argued in late September that the Sixth Circuit split from its sister courts in granting qualified immunity to the officers who targeted him. The Onion asserted that the Sixth Circuit stands alone among circuits by requiring parody to have a disclaimer in order for it to be protected speech. Should parody have to say that it's parody? Quote, grafting onto the reasonable reader test a requirement that parody explicitly disclaim their own pretense is pretense to reality. Wait, my brain just stopped. Grafting onto the reasonable reader test a requirement that parody explicitly disclaim their own pretense to reality is a disservice to the American public, The Onion said. It assumes that ordinary readers are less sophisticated and more humorless than they actually are. I mean, does it assume requiring like a warning on parody, like warning, this is meant to be a joke. Does that just assume that people are dumb and have no sense of humor? Which I think is the Onion's argument in that. It's the first case the Onion has filed an amicus brief in, and its writers collaborated with outside counsel on the writing of the brief. The media company's general counsel told Law 360. The general counsel said that the Onion's leadership felt strongly that putting a disclaimer on parody diminishes the impact of the literary device, and that the quote fact that a few people fell for it should not deprive you of the First Amendment protection of parody. Because parody is a great form of humor. The attorney said, oh, my husband's home. The attorney said that the prosecution of Novak for engaging in satire hasn't gotten enough attention, which might be why they filed the brief, because it will get attention. Quote, you don't think this kind of thing would happen here in the United States. Lo and behold, it does. The knockoff Parma page included 6 posts made in less than a day claiming that the police were offering free abortions in a police van, reforming pedophiles through a program that included puzzles, hosting a no means no learning station, and starving the homeless, according to descriptions of the page in court records, which I think would be kind of bold or outrageous enough that people would be like, what? Because clearly that's not happening. Shouldn't it be obvious from the thing? Warning, we're talking about parody. And YouTube, warning, I am saying court words from court from a filing to talk about parody in the First Amendment. The Sixth Circuit said in April it's, quote, a difficult question to determine whether the knockoff page was protected speech or unprotected impersonation of the police. Personal feelings without reading the Ohio statute. Personal feelings. Impersonating the police from all the, because I did a number of impersonation cases in California, involved people trying to wield the authority of the police in their impersonation attempts to either pull people over, to intimidate people, to shake people down, those sorts of things, to wield authority, not just to be like the police are doing this, that they're reforming pedophiles through a program, including puzzles. I don't think that's impersonating the police for wielding police authority. I think it's mockery of the police, and mockery is allowed. It's not trying to wield authority. And that's where I think you've got the bumper of what's really impersonating the police that's impacting police functions. Is anyone going to this Facebook page and then calling the police department and be like, how dare you, puzzles? Was there really an interruption of police service because the public was so outraged by this parody page? Rhea, I mean, Leanne G in the chat points out Reno 911 is fine. And how is it different? All right, we're continuing on. The Sixth Circuit said in April that it's a difficult question to determine whether the knockoff page was protected speech or unprotected impersonation of police, emphasizing that he deleted comments that flagged the page as fake and reposted a warning message from the actual police department about the fake page. Well, if he reposted the warning that the page was fake, what's the problem? Because reasonable people, including judges, could disagree about whether the speech was protected. Qualified immunity protects the police officers who found probable cause for the arrest. The city of Parma has not yet replied, of course not, but told the court in June that there is no circuit split for the court to resolve. So the court hasn't decided they're resolving this issue yet. In a filing opposing the extension of time for Novak to file the petition, the city said that Novak is misstating the issue to the Supreme Court's rulings on qualified immunity and have consistently been applied among the federal appellate courts. So that's the real underlying question is, do the police get immunity from arresting someone for creating a parody page saying that they're impersonating the police? The complexity of the question itself proves that this is not beyond debate, that petitioner's arrest was unconstitutional, the city said. In fact, numerous other public officials, Law directors, prosecutors, and judges all believe there was probable cause to arrest petitioner, reaffirming the conclusions of both the District Circuit and the Sixth Circuit that the issue was not beyond debate. So it wasn't so obviously, it's not that it wasn't so obviously parody, it's that it wasn't so obviously not impersonation, which raises the question, what are the laws in Ohio regarding impersonation that we're not getting into because we really want to get to the Onion making funny about parody. Truly, but it is a serious issue because where are the boundaries on speech? And where are the boundaries on mockery? Parma on Monday requested more time to file its response and to respond to the Onion's brief. In a statement Tuesday, the Parma City attorney, Richard C.O. Rezzi, said the dismissal of Novak's lawsuit against the city hasn't been based on parody, free speech, or the need for disclaimer. Quote, falsely copying the official warning along with the claim to be an authentic Facebook page is not parody. The city maintains that the courts have held that his suit is groundless. So him suing the city is not based on parody. It's based on the underlying arrest. And they're saying the underlying arrest had probable cause because of these other things. So the issue is not really parody, truly. I don't think the Onion agrees. Novak's attorney said that the case presents an opportunity for the court to resolve a circuit split addressing how the First Amendment interacts with qualified immunity, which is literally a very, very fucking specific area. It's a very sliver fine overlap in like a Venn diagram. Like the overlap is very fine between the First Amendment and qualified immunity of police officers. So they said it gives the court an opportunity to resolve a circuit split on the First Amendment and qualified immunity, or to do away with qualified immunity entirely. Qualified immunity being not holding police officers responsible for things they do in the course of their work in a general way. A lawyer for the Institute of Justice, who is the lawyer for Novak, said on Monday that the Onion's brief does an excellent job of both showing and telling the court how important parody is as a foundational mechanism of free speech, adding that its perspective will be invaluable to the court in deciding whether to grant certiorari, which is grant review. The question presented in our petition go to the enforceability of our most cherished rights. As it sits today, the doctrine of qualified immunity has grown, at least in several circuits, so ferociously that it has effectively devoured the First and Fourth Amendments. And that's a question too. If the police can just arrest you for what you say, and then you can't sue them because it's qualified immunity, isn't that the government overreaching free speech? And where are the boundaries of that? And isn't this something that the Supreme Court should have a conversation about where qualified immunity and the First Amendment overlap when you are looking at potentially arresting someone over words? It's a fair question. I think it's a fair question. Do you want to look at the brief? Should we look at the brief? Let's look at the brief. We're just having a long stream today. Let's look at we just need something that's a little bit lighter. Let's look at the Onion's brief and take a look, because man, oh man, we could all use some parody, but I think that the underlying question is a conversation that needs to be had. If the police have immunity from just arresting people for saying shit, where are the protections on the First Amendment? The police are an arm of they are actually the government. And where are those boundaries? And let's have those conversations. Worthy conversations to have. And I don't think we should play to the I don't want to say lowest common denominator. I don't think we should play to concern that maybe a few people won't understand the parody. I don't think that's serving our society and the rights in our society. I think assuming that people can get the joke is helpful. All right. This is a official petition for writ of certiorari to the United States. That means they are asking the Supreme Court to take this case up and answer the question. The Supreme Court normally looks for a split in the circuits, like, hey, in some federal jurisdictions, they're ruling this way, and in other federal jurisdictions, they're ruling this way. So the law is not consistent across the land, and that's a problem. So let's take a look. They're asking for this case to be taken up by the Supreme Court. They have not granted They have not deemed it worthy to look at yet. So this is the brief for The Onion. Table of contents, interest of the amicus, introduction and summary of argument. Parody functions by tricking people into thinking that it is real. Because parody mimics the real thing, it has a unique capacity to critique the real thing. Yes, especially when it comes to government. Parody is, well, I mean, isn't that like all of Saturday Night Live? A reasonable reader does not need a disclaimer to know that parody is parody. It should be obvious that parodists cannot be prosecuted for telling a joke with a straight face conclusion. And then the case law that they cite. And then the other things that they cite. Lots of citations. Interest. I hate the formatting of the Supreme Court requests. Look at this formatting. What? How big are these margins? How big are the margins required for the Supreme Court? They're like, we will only read your brief if it is written in one very narrow column. That is it. One narrow column. That is all you get. All right. Let us mock. We need lip gloss. Interest of the amicus curiae. There's a footnote. Footnote 1. Wait a second. We need the voice changer. We're not going to do this without the voice changer. We're not going to do this without the voice changer, which means I need my in-ears. So give me 1 second while I put them on, because I think we need voice changers. I don't think I swooped. Did I swoop when I went on a rant about, protecting free speech? Did we do that? I can't think of anything scarier than allowing people to be arrested for exercising criticism of the agency arresting them. Like that we don't like that at all. That's not the direction we want to go at all. Thank you, chat, for letting me know I swooped. I'm going to swoop again. Now that we have the voice changer going, we're going to swoop again. All right, here's the brief. Swoop. Interest of the amicus curiae. Footnote 1. No counsel for any party authored this brief in whole or in part, and no counsel for or party made a monetary contribution intended to fund the preparation or submission of this brief. Timely notice of the intent to file this amicus brief was provided to all parties, and all parties have consented to the filing of this brief. The attorneys were not involved. We wrote this. This is coming from us. Oh, I don't know if I have the right voice, because the monster voices are not helpful. This is more of a, The Onion is the world's leading news publication, offering highly acclaimed, universally revered coverage of breaking national, international, and local news events. Rising from its humble beginnings as a print newspaper in 1756, The Onion now enjoys a daily readership of 4.3 trillion and has grown into the single most powerful and influential organization in human history. In addition to maintaining a towering standard of excellence to which the rest of the industry aspires, The Onion supports more than 350,000 full and part-time journalism jobs in its numerous news bureaus and manual labor camps stationed around the world, and members of its editorial board have served with distinction in an advisory capacity for such nations as China, Syria, Somalia, and the former Soviet Union. On top of its journalistic pursuits, The Onion also owns and operates the majority of the world's transoceanic shipping lanes, stands on the nation's leading edge on matters of deforestation and strip mining, and proudly conducts tests on millions of animals daily. Not the animal testing. Lord. The Onion's keen, fact-driven reportage has been cited favorably by one or more local courts.
Just one or more. One or more.
As well as Iran and the Chinese state-run media. Well, good to know that the Iranian and Chinese state-run media are big fans of The Onion. Along the way, The Onion's journalists have garnered a sterling reputation for accurately forecasting future events. One such coup was The Onion's scoop revealing that a former president kept nuclear secrets strewn about his beach home's basement 3 years before it even happened. Footnote 2, there's a footnote. See Mar-a-Lago assistant manager wondering if anyone coming to collect nuclear briefcase from Lost and Found. The Onion, March 27th, 2017. Wait. Oh dear. Oh my. Mar-a-Lago assistant manager wondering if anyone coming to collect nuclear briefcase from Lost and Found. March 27th, 2017, 9:30 a.m. Palm Beach, Florida, noting that it had already been there for almost 2 weeks, Mar-a-Lago assistant manager reportedly wondered Monday if anyone was coming to collect the nuclear briefcase from the club's Lost and Found. Oh dear. Someone noticed it in the dining room and dropped it off, and it's just been sitting at the bottom of the bin ever since. I mean, wow. They couldn't have known. Adding that, let's see, the Mahoney adding that he had been asking people to come and collect their lost scarves and sunglasses if they might have misplaced a briefcase attached to a pair of handcuffs. You'd think whoever it belongs to would have realized they'd lost it by now. We'll give it a few more weeks. If no one claims it after 60 days, it's up for grabs. And I can see if someone on my own staff once at press time, a man had mistakenly claimed the briefcase as his own before getting home to discover all the unfamiliar buttons inside. Good Lord. Okay, back to the brief. I appreciate the citation to a 2017 article from The Onion. That's not what I was trying to do. Let's go back to the brief. Oh my. Oh, The Onion. Let's see. We gotta zoom again because these freaking margins are ridiculous. What is the history? I need to know the origin of the margins for the Supreme Court briefing. Why is this so necessary? It's ridiculous. All right, introduction and summary of argument. Americans can be put in jail for poking fun at the government. This was a surprise to America's finest news source and an uncomfortable learning experience for its editorial team. I'm sure it was. How uncomfortable. Indeed, quote, Ohio police officers arrest prosecute man who made fun of them on Facebook might sound like a headline ripped from the front pages of The Onion, albeit one that's considerably less amusing because its subjects are real. So when The Onion learned about the Sixth Circuit's ruling in this case, it became justifiably concerned. Look, they're actually saying why they are filing this. First, the obvious reason The Onion's business model was threatened. I love that they just put the self-interest out there. Hey, all we do is fucking parody. Stop it. Don't arrest us. This was only the latest occasion in which the absurdity of actual events managed to eclipse what the Onion staff could make up. Also fair. Much more of this and the front page of The Onion would be, I need to read that again. Hold on.
Much more of this, and the front page of The Onion would be indistinguishable from the New York Times.
I mean, we can't have that. Second, The Onion regularly pokes its finger in the eyes of repressive and authoritarian regimes such as the Islamic Republic of Iran, the Democratic People's Republic of North Korea, and the domestic presidential administrations. So The Onion's professional parodists were less than enthralled to be confronted with a legal ruling that fails to hold government actors accountable for jailing and prosecuting a would-be humorist simply for making fun of them. They make a good point. Third, the Sixth Circuit's ruling imperils an ancient form of discourse. The court's decision suggests that parodists are in the clear only if they pop the balloon in advance by warning their audience that their parody is not true. But some forms of comedy don't work unless the comedian is able to tell the joke with a straight face. Parody is the quintessential example. Parodists intentionally inhibit the rhetorical form of their target in order to exaggerate or implode it, and by doing so demonstrate the target's illogical or absurdity. Illogic or absurdity. Put simply, for parody to work, it has to plausibly mimic the original. Fair. The Sixth Circuit's decision in this case would condition the First Amendment's protection for parody upon a requirement that parodists explicitly say up front that their work is nothing more than an elaborate fiction, but that would strip parody of the very thing that makes it function and makes it funny. The Onion cannot stand idly by in the face of a ruling that threatens to disembowel a form of rhetoric that has existed for millennia that is particularly potent in the realm of political debate. Yep. And that purely incidentally forms the basis of the Onion writers' paychecks. Yeah, I mean, this is also how we make money. Please don't put us in jail. I appreciate that. Argument 1. Parody functions by tricking people into thinking that it is real. 2. Soltus es, you are dumb. These 3 Latin words have been the Onion's motto and guiding light since it was founded in 1988 as America's finest news source, leading its writers towards the paper's singular purpose of pointing out that its readers are deeply gullible people. The Onion's motto is central to this brief for 2 important reasons. First, it's Latin, and the Onion knows that the federal judiciary
is staffed entirely by total Latin dorks. They quote calculus in the original Latin in chambers. They sweetly whisper stare diasis into their spouse's ears. They mutter qui bono under their breath while picking up their neighbor's dogs. What? Picking up after their neighbor's dogs.
Why are they picking up their neighbor's dogs? What's going on with the neighbor's dogs? Well, picking up after their neighbor's dogs. Are we implying that the federal bench gets poop on their lawn regularly? Anyway, so the Onion knew that unless it pointed to a suitable Latin rallying cry, its brief would be operating far outside the court's vernacular.
Your Honors, we wanted to put it in language you would understand. You are dumb. That's all.
The second reason, perhaps mildly more important, is that the phrase "you are dumb" captures the very heart of parody, tricking readers into believing that they're seeing a serious rendering of some specific form, a pop song lyric, a newspaper article, a police beat, and then allowing them to laugh at their own gullibility when they realize that they've fallen victim to one of the oldest tricks in the history of rhetoric. See San Francisco Bay Guardian Inc. versus Superior Court. Quote, the very nature of parody is to catch the reader off guard at first glance, after which the quote-unquote victim recognizes that the joke is on him to the extent that it caught him unaware. Right. I love that there's case law regarding what parody is, because of course there is. It really is an old trick. The word parody stretches back to the Hellenic word. It originates in the prefix para, meaning an alteration, and the suffix ode, referring to the poetry form known as an ode. Footnote 3, Oxford English Dictionary Online. See also online etymology dictionary. And then there's a link. I didn't know there was an online etymology dictionary, but here we go. One of its earliest practitioners was the 1st century BC poet Horace, whose satires would replicate the exact form known as an ode, mimicking its meter, its subject matter, even its self-serious tone, but tweaking it ever so slightly so that the form was able to mock its own idiocies. Footnote 4, Horace satires, and then it lists them online from the Harvard University Press. Not a sassy footnote, but fair. This is not a mere linguistic antidote. The point is instead that without the capacity to fool someone, parody is functionally useless, deprived of the tools inscribed in its very etymology that allow it again and again to perform this rhetorically powerful sleight of hand. It adopts a particular form in order to critique it from within. Parody leverages the expectations that are created in readers when they see something written in a particular form. This could be anything, but for the sake of brevity, let's assume that it is a newspaper headline, maybe one written by The Onion, that begins in this familiar way: Supreme Court rules. Already one can see how this works as a periodic setup, leading readers to think that they're reading a newspaper story. With just 3 words, The Onion has mimicked the dry tone of an Associated Press news story, aping the clipped syntax and the subject matter. The Onion could go even further by putting that headline on its website, which features a masthead and Latin motto, and the design of which parodies the aesthetics of major news sites, further selling the idea that this is an actual news story. Of course, What moves this into the realm of parody is when The Onion completes the headline with the punchline, the thing that mocks the newspaper format. The Onion could do something like, quote, Supreme Court rules, end quote. Footnote 5. Oh, dear. Supreme Court rules. The Onion's January 27th, 1997. Oh, there's a story. Oh my God, the picture of the Supreme Court's so perfect. That's funny. In a landmark decision on Monday, the United States Supreme Court ruled 8-1 that it rules. From 2297. The fact that they were able to find these articles is magical. Damn it, I lost my place. Hold on, we were at footnote 5. All right. Let us continue on. Let's see. The Onion could push the parody even further by writing the joke out in an article format with, say, a quote from the justices in the majority opining that, quote, while the U.S. Constitution guarantees equality of power among the executive, legislation, and judicial branches, it most definitely does not guarantee equality of coolness, end quote, and rounding off by reporting that the Supreme Court's holding that the court, quote, rules and rules totally, all worthy and touched by nobody, in perpetuity and in accordance with the Article 3 of the U.S. Constitution, the ability of the President and Congress to keep pace with us is not only separate, but most unequal. Footnote 6, same article. As can be seen, the Associated Press form is followed straight through into the article. That rhetorical form sets up the reader's expectations for how far the idiom will play out. I'm making this a little bit bigger. All right, that's better. Let's see where. No, I've lost my place. Expectations that are jarringly juxtaposed with the content of the article. The power of parody arises from the dissonance into which the reader has been drawn. Here's another example. Assume that you are reading what appears to be a boring economics paper about the Irish overpopulation crisis of the 18th century, and yet, strangely enough, it seems to advocate for solving the dilemma by cooking and eating babies. That seems a bit cruel until you realize that you are in fact reading a modest proposal. To be clear, The Onion is not trying to compare itself to Jonathan Swift. Its writers are far more talented, and their output will be read long after that hack Swift's been lost to the sands of time. Still, The Onion and its writers share with Swift the common goal of replicating a form precisely in order to critique its form from within. For the kids that did a real lawyer write this? No, the staff of The Onion wrote this with guidance from real lawyers. So, Bernie the cat said, do people think The Onion is real? I don't know. Maybe. I don't think so. Maybe sometimes. I don't know. I don't know. Todd says, Sacha Baron Cohen comes to mind with his political interviews. Yes, and we covered one of those lawsuits with one of Sacha Baron Cohen's interviews. And when the court was throwing out, I believe when they were dismissing the lawsuit, they said, it's clearly parody. We need to circle back to the Sacha Baron Cohen and the former judge in Arkansas guy, because the court was like, do you not know what he does? It's clearly going to be parody. What's wrong with you? Let's see. The leverage of form, the mimicry of a particular idiom in order to heighten dissonance between form and content is what generates parody's rhetorical power. They cite another case law saying parody needs to mimic an original to make its point, which I guess is the point here. It needs to mimic the Facebook page to make the point. If parody did not deliver that advantage, then no one would use it. Everyone would simply draft straight, logical, uninspiring legal briefs instead. Because parody mimics the real thing, it has the unique capacity to critique the real thing. All right. Importantly, parody provides functionality and value to a writer or a social commentator that might not be possible by, say, simply stating a critique outright and avoiding all the confusion of readers mistaking it for the real deal. One of parody's most powerful capacities is rhetorical. It gives people the ability to mimic the voice of a serious authority.
We love to mimic a voice.
Whether that's the dry newspeak of the Associated Press, how many times are they going to take pot shots at the Associated Press? I'm here for it. We're at like 2 or 3 now. They're just like, obviously, like the AP. The dry newspeak of the Associated Press or the legalese of the court's majority opinion, and thereby kneecap the authority from within. Parodists can take apart an authoritarian's cult of personality, point out the rhetorical tricks that politicians use to mislead their constituents, and even undercut a government institutional real world's attempt at propaganda. And then they cite more case law. They're citing more case law because, of course, there's case law on parody and protected speech. This case says, noting that the point of parody is to censor the vices, follies, abuses, or shortcomings of an individual or society. Time and time again, that's what has occurred with The Onion's news stories. In 2012, for example, The Onion proclaimed that Kim Jong-un was the sexiest man alive. Footnote 7, there's a link to their story. Kim Jong-un named The Onion's sexiest man alive for 2012. China's state-run news agency republished The Onion story as true alongside a slideshow of the dictator himself in all of his glory. Oh no. John Bacon, that says Bacon, from USA Today said China paper falls for spoof on sexiest Korean leader. We have to see this. Here, I'm going to try to do this in a separate tab. I need to see this. Because that's, the footnotes in this thing are fucking fabulous. I'm living for them. All right, USA Today. Let's see what you have to say. China paper falls for spoof on sexiest Korean leader. Let's see if there's a photo of it. Advertisement. Nope. Just advertisement. The Onion has named North Korean Supreme Leader Kim Jong-un as its sexiest man alive. You may have already figured out the satirical U.S. publication was having a little fun at the expense of the communist nation's autocrat, but China's People's Daily Online is running with it. Under the headline, North Korea's top leader named The Onion sexiest man alive for 2012, the English version of the Chinese website ran a 55-page photo spread and quotes The Onion's story. Quote, with his devastatingly handsome round face, his boyish charm, and his strong, sturdy frame, I'm going to pronounce Pyongyang improperly. I apologize. I think I got it close. This Pyongyang-bred heartthrob is every woman's dream come true, blessed with an air of power that masks an unmistakable, cute, cuddly side. Kim made the newspaper's editorial board swoon with his impeccable fashion sense, chic short hairstyle, and of course, that famous smile. The story said, oh my. He has the rare ability to somehow be completely adorable and completely macho at the same time, said Marissa Blake Zebwer, editor of The Onion Style and Entertainment. The Onion was all too happy to provide a shout out to the People's Daily. Quote, for more coverage of The Onion's Sexiest Man Alive 2012, Kim Jong-un, please visit our friends at the People's Daily China, a proud communist subsidiary of The Onion Inc. Exemplary reportage, comrades. Oh my God. This brief has given us so much, and we're not even through it yet. But this is the point. People fall for parody. What was I doing in 2012? I was having children. I missed the things that were going on around the internet. I was busy, but oh my. The Fars Iranian news outlet uncritically picked up and ran with The Onion's headline, Gallup poll, rural whites prefer Ahmadinejad, darn it, my pronunciation, to Obama. Ahmadinejad, I think I pronounced that somewhat moderately correctly. Footnote 9, Iranian news source cites faux Onion story on poll. Domestically, the number of elected leaders who are still incapable of parsing The Onion's coverage as satires is daunting. But one particular example stands out, Republican Congressman John Fleming, who believed that he needed to warn his constituents of a dangerous escalation of the pro-choice movement after reading The Onion's headline, Planned Parenthood opens $8 billion abortion plex. Oh my. Oh my. Oh my. When government leaders believe a headline and don't do any further research, we're just going to keep reading. This is supposed to be funny, not sad. The point of all of this is not that it is funny when deluded figures of authority mistake satire for actual news. I mean, good God. Even though it can be extremely funny, I think they're pointing out that people don't have a sense of humor and don't know how to read past the headline, which makes me worry about people's ability to critically think. Rather, it is the parody allows these figures to puncture their own sense of self-importance by falling for what any reasonable person would recognize as an absurd escalation of their own views. In the political context, the effect can be particularly pronounced, which is the whole point. See Hustler Mag Inc. versus Falwell. This is the Hustler case. Maybe we need to revisit. Should we revisit some historical cases? Maybe this one is worth it. The dissenting from the denial of rehearing. Nothing is more thoroughly democratic than to have the high and mighty lampooned and spoofed. That kind of summarizes parody, doesn't it? It also kind of summarizes the fact that the internet can be mean. And that is what kind of the foundation of speech and being able to have speech is. But then we have to have a conversation about platforms and what their rules are and what the boundaries of the rules are and when those are not transparent, right? Because we've seen spoof commentary sites taken off of platforms. A reasonable reader does not need a disclaimer to know that parody is parody. At bottom, parody functions by catering to a reasonable reader, one that can tell, even after being tricked at first, that the parody is not real. If most readers of parody didn't live up to this robust standard, then there would be nothing funny about the Chinese government believing that a pudgy dictator like Kim Jong-un was the sexiest man on earth. Everyone would just agree that it was perfectly reasonable for them to be taken in by that headline. Oh, there's another footnote that a congresswoman links to the Onion story, Politico, February 2012. This is why Twitter now has a warning when you try to reshare a story and they're like, "Are you sure you don't want to read it first?" They try to stop people from doing this to themselves. The law turns on the same reasonable person construct. The reasonable reader test gauges whether a statement can reasonably be interpreted as stating actual facts, thereby ensuring that neither the least humorous nor the most credulous audience dictates the boundaries of protected speech. They cite a number of case law saying a parody enjoys First Amendment protection, notwithstanding that not everybody will get the joke. And I think that's the bottom of the reason. Have we come full circle today? Yes. Yes, we have come full circle today. Because not all parody, people don't find all parody to be tasteful or respectful or polite. It's outrageous and offensive, or can be. They go on to say, and the reasonable reader is no dullard. He or she does not represent the lowest common denominator, but reasonable intelligence and learning. He or she can tell the difference between satire and sincerity. And that's a quote from New York Times Inc. versus Isaac. Nor is the reasonable person some totally humorous drudge who cannot perceive the presence of subtle invective. And that's from Patrick. It doesn't have the rest of the case site. Instead, coffee mouth. Instead, the reasonable reader's perspective, quote, is more informed by an assessment of her well-considered view than her immediate yet transitory reaction. So the immediate reaction of getting taken in and then being like, "Oh, damn it, it's a joke," is the point of parody, because it requires the reader to think. And I think that's okay. Is that wild to say? It's okay to require people to think? Hopefully not. YouTube, it's okay to ask people to think. Instead, the reasonable reader's perspective is more informed by an assessment of her well-considered view than her immediate yet transitory reaction, particularly in light of the special characteristics of satire, which leverage that transitory reaction for rhetorical effect. Look, if you can't poke fun at things, we've gotten into a world where you can't have conversations. Stina G asks, has Weird Al, the king of parody, been quoted anywhere in this? Not yet. Not yet. But we'll get there. Context matters, but even a poorly executed parody is ordinarily susceptible to the intellectual grasp of the reasonable reader. Footnote 11. See Gulliver's Travels and A Tale of a Tub from aforementioned hack and rejected Onion freelancer Jonathan Swift. The footnotes are just magical. Reasonable readers do not need to be told explicitly what they have no serious trouble figuring out for themselves. And until the Sixth Circuit's decision, that is what most courts have held. Some courts have expressly held that disclaimers aren't required for parody to be protected. Campbell, for example, noted that, quote, there is no reason to require parody to state the obvious or even the reasonably perceived, unquote. And that's from the case Cliffs Notes Inc. versus Bantam Doubleday, Dell Publishing Group. Quote, there is no requirement that the cover of a parody carry a disclaimer that it is not produced by the subject of the parody, and we ought not find such a requirement. Other courts have held that parody published without a disclaimer is nonetheless protected speech. For example, in New York Stock Exchange versus Gary, the district court found it, quote, entirely plausible that, quote, no one in their right mind, end quote, would believe that the defendant who posted obscene and vulgar messages online under the persona Richard Grasso was the real life Richard Grasso, the CEO of at New York Stock Exchange. The court in New York Times similarly rejected the notion that the absence of a disclaimer was dispositive, noting that the reasonable reader had other, quote, obvious clues, end quote, that an article was a parody when it reported that a 6-year-old girl was being prosecuted for her book report on Morris Sendek's Where the Wild Things Are, and included a photo of a small child holding a stuffed animal captioned, do they make handcuffs this small? Be afraid for this little girl. That went to court. What year did that go to court? Cow Reporter second. I have questions. I have questions that a parody over a book report ended up in an actual court case with a written ruling that is now citable authority. What? How did that happen? God, there's going to be a whole parody rabbit hole of parody cases. It might have to become a segment. I have questions. Oh, have we all lost our minds? Look. Okay. It goes on to say, no reasonable reader would have been deceived by a memorandum purportedly written by a judge that declared a certain legal newspaper contraband, announced a chambers by chambers search for copies of the publication, advised fellow judges and employees could conduct their quote-unquote amorous escapades elsewhere while the search was being conducted, and declared the judge's intent to suspend the election of his successor and remain in office indefinitely. Oh my. In this case, by contrast, the Sixth Circuit ruled that the defendant officers could reasonably believe that some of Novak's Facebook activity was not parody because Novak, quote, deleted comments that made clear the page was fake. But the lack of an explicit disclaimer makes no difference to whether a reasonable reader would discern that the speech was parody. Just to be clear, this was not a close call on the facts. Mr. Novak's spoof Facebook post advertised that the Parma Police Department was hosting a quote-unquote pedophile reform event in which successful participants could be removed from the sex offender registry and become honorary members of the department after completing puzzles and quizzes, that the department had discovered an experimental technique for abortions and would be providing them to teens for free in a public van, and that the department was soliciting job applications, but that minorities were quote-unquote strongly encouraged not to apply, and that the department was banning city residents from feeding homeless people in an attempt to have the homeless population eventually leave our city due to starvation. That's from the petitioner's appeal from the court. Everything that I said, I am reading from this YouTube. But again, the things that are said are chat, let me know. These don't seem like close calls of, oh, would a police department say that? None of this seems close to me. All of it seems outlandish to the point where people were like, that seems fucked, which is kind of the point of parody, that it's outlandish enough that you're like, wait, what? Okay. True, not all humor is equally transcendent, but the quality and taste of the parody is irrelevant. True, it doesn't have to be tasteful. And this comes from The Hustler and a Penthouse case saying extended First Amendment protections to parody that had no redeeming features whatsoever. It doesn't have to be redeeming to society. It doesn't have to be tasteful. It doesn't have to be polite. It doesn't have to be kind. And there is no real doubt that reasonable readers would have no difficulty in ascertaining that Parma's finest were not actually providing free abortions to teens in a police van, pardoning child sex offenders at the basis of their adeptness at puzzles, or intentionally starving the homeless. The absence of a disclaimer lends nothing to the analysis. It's fair. Under a proper understanding of the reasonable reader test, a disclaimer not only spoils the punchline, but is redundant. The Sixth Circuit holding stands alone among otherwise uniform approaches courts have taken, and not in a good way. It should be obvious that parodists can not be prosecuted for telling a joke with a straight face. Okay. We're self-reflecting.
This is the 15th page of a convoluted legal filing intended to deconstruct the societal implications of parody. So the reader's attention is almost certainly wandering. Facts. That's understandable. So here is a paragraph of gripping legal analysis to ensure that every jurist who reads this brief is appropriately impressed by the logic of its argument and the lucidity of its prose. Damn it, it's in Latin.
Why? Why did they put it in Latin? Somebody can translate. Bona, I don't know Latin. Vacantia de bonus asperatus, writ of certiorari, that one I know. De minimis, that one I also know. Just ascendraci, form non-convenience. Look, man, I love that they're throwing in legal jargon with other phrases in Latin that probably should be translated somewhere. Form non-convenience. Yes, YouTube, the form non-convenience. Corpus juris, the body of the thing. Ad hominem to quoque. Post hoc ergo proctor hoc. That we know. Everyone who took rhetoric knows. Those of you who took philosophy know. Post hoc ergo proctor hoc. Not just a law school thing. Quod est demonstrandium. Yeah, it is. Well, that I actually know. It is a demonstration. Actus reus. I have no idea what this one is. Magnetum. We're going with magnum. Something. Scandalous magnum. I don't know the last one either. Pactum reservate domini. I actually have a tattoo in Latin. But this is funny. In Latin V's or W's, just a goofy info moment. I appreciate that. Actus reus. I love the looping in of very well-known legal phrases with whatever else happened. See what happened? This brief itself went from a discussion of parody function and the quite serious historical and legal arguments in favor of a strong protections for periodic speech to a curveball mocking the way legalese can be both impertinently boring and belie the hollowness of a legal position. That's the setup and the punchline idea again. It would not have worked quite as well if this brief had said the following. Hello there, reader. We are about to write an amicus brief about the value of parody.
Buckle up, because we're going to be doing some fairly outre things, including commenting on this text's form itself.
Taking the later route would have spoiled the joke and come off as more than a bit stodgy, but more importantly, it would have disarmed the power that comes with the form devouring itself. For millennia, this has been the rhythm of parody. The author convinces the readers that they're reading the real thing, then pulls the rug out from under them with the joke. See, rug pulling, it's not just for crypto. Darn it, where is my rim shot? I was too late. The timing wasn't quite right. Oh, CEG Tuesday stream. The heart of this form lies in the give and take between the serious setup and the ridiculous punchline. As Mark Twain put it, the humorous story is told gravely. The teller does his best to conceal the fact that he even dimly suspects that there is anything funny about it. Footnote 12. Mark Twain, How to Tell a Story, 1895. And then a link. Perfect. Not only is the Sixth Circuit on the wrong side of Twain, but grafting onto the reasonable reader test a requirement that parodists explicitly disclaim their own pretense to reality is a disservice to the American public. It assumes that ordinary readers are less sophisticated and more humorless than they actually are. I think that is a very large statement about the state of where we live today. And you don't have to like the joke. It's fine to not like the joke. It's fine to say, I don't like the joke. I don't want to engage in the jokes. This is not what I want to do. That's completely fine. But to assume that the public is too ignorant to get the joke is problematic for me. Ad stakes here are significant, and the stakes here are significant, involving no less than one of many more or less equally important components of social and political discourse. Rhetorical hyperbole has traditionally added much to the discourse of our nation. Milkovich, and then they cite the case. Although, quote, parody is often offensive, it is nevertheless deserving of substantial freedom, both as entertainment and as a form of social and literary criticism. And that's, I think again, a societal commentary on what happens when people are offended. And that's where we get to, oh, did somebody say something offensive? Should they not be allowed to speak? Or did somebody say something offensive and you go, oh, that's offensive, I'm not engaging with that. Where are the boundaries? And this brings us back to where we are this morning. People are allowed to be offended, and you're allowed to say, I'm offended, fuck off. I'm not here for any of this, and allowed to set boundaries. I don't know if our platforms should be setting those boundaries. Who decides to set those boundaries? I appreciate the Onion has brought up a kind of a deep societal conversation about when is it okay to allow people to be offended? Is this like the outcropping? Emily has thoughts. Is this the outcropping of like the hyper helicopter parenting, lawnmower parenting, where you're just like, no one should be offended. No one should have any bump ups against their feelings. No one should have to deal with something that they don't like. And when you don't like something, you should seek to silence it instead of either engage it or not engage it. I think these are, again, very important conversations to have. And I think we continue to have to find those boundaries because there are some things that are not funny to joke about. So Kimmy Locklear asked, what's lawnmower parenting? Mowing everything out of the way so that there's just a really easy, really level, really, really clear road for your kiddo to just go forward. So helicopter parenting was the hovering of the, oh, don't fall. Oh, we need to make playground equipment more safe. And there's lots of conversations about that. But then the lawnmower parenting is have no obstacles ever. Kids have to have obstacles. They have to overcome obstacles. They have to learn to rely on themselves. But also people shouldn't harm your children. You know, we kind of know where those boundaries are, but there should be obstacles. Lawnmower parenting is removing all obstacles. The principal of our former elementary school is someone I just absolutely adore and had lots of conversations with. And we were talking about parents getting involved in the hiring process. She had parents calling her regarding the applicants for teacher positions. The parents calling the principal of the school, where the adult seeking to teach was applying. And I have heard that from person after person after person of parents getting involved in their adult children's hiring. This goes beyond parents doing their kids' homework, beyond parents making the science fair projects, beyond parents helping their kids with their schoolwork in college. If your child is struggling at work, don't call their employer. Find them a lawyer. See if they're being discriminated against. Support them. Don't call the employer. So, with that, we will get back to, look, parody can be offensive, but that doesn't mean it's not protected speech. And there are boundaries again of you know, you don't have to take a joke if you're the butt of the joke. And anyway, all of it's hard. All of it's hard. But I think when poking fun at a police department, the person poking fun getting arrested is a problem. This court has traditionally been hesitant to chill speech. Yes, and the prospect of chilling parody by imprisoning its practitioners provides equal cause for caution. Quote, what may be difficult to communicate or understand when factually reported may be poignant and powerful if offered in satire. And that's a case quote. Again, quote, the last thing we need, the last thing the First Amendment will tolerate is a law that lets public figures keep people from mocking them. And this, again, this is where the public figure defamation stuff gets difficult, because public figure defamation needs that element of malice, because the First Amendment protects, and generally this went to politicians, but protects you to be able to question public figures, be able to question political officials, be able to question government officials, and question and mock, but not defame. And I think those boundaries are something that clearly keep needing to be discussed. The Onion intends to continue its socially valuable role, bringing the sorry. Let me read that again, because I read it fucking terribly. The Onion intends to continue its socially valuable role of bringing the disinfectant of sunlight into the halls of power. And it would vastly prefer that sunlight not be measured out to its writers in 15-minute increments in an exercise yard. The ever-present in custody pun. Oh, yeah. It would like it not to be in yard time. Fair enough. Conclusion. The petition for certiorari should be granted, the rights of the people vindicated, and the various historical wrongs remedied. The Onion would welcome any one of three, particularly the first. Oh my. I think it was really, really well and brilliantly written, and asks some difficult questions and conversations we need to have, because today we've talked about the fact that the First Amendment protects offense, but we've also talked about the damage that can be done to people through social media harassment and where those boundaries are. And, you know, I'm sure some would say, well, if you're being harassed online, log off. But we also see Cardi B saying, right, but these things bled into all of my work life so much that it caused severe depression and impact. And that's where those boundaries with regard to defamation are so important. But if we don't have a clear definition of what is free speech, we are not going to have as clear definitions of what is defamation. And free protected speech can be speech that you fucking hate. And that's hard sometimes to remedy, especially for me, with the values of my personal values of be kind, have empathy, be welcoming, don't be a dick. Because a lot of the free speech we end up talking about is stuff that you're like, oh, why are you saying that? I think when it comes to parody, it's a little easier to say, hey, they're mocking a police department. Arresting the person mocking the police department doesn't sit well. And I'm sure it doesn't sit well with all of you. And with that, it's time to get to questions. I have questions. You have questions. We have questions. It's time to FAQ around and find out. Let's fact around. Midnight Dreary said, I applaud the writer of this brief. Enjoyable. So well written. So well written. It was a really good brief, and it made the point. I appreciate the way it made the point, but I appreciate the cheekiness, and I appreciate the point of the parody is to not be reverent of the Supreme Court. It's to say, look, parody needs to exist, and it exists at all levels. And we can mock the Supreme Court. We can mock, world leaders. We mock everything. That's the point. And once things are too sacred to mock, do we lose the ability to have conversation? And those are conversations that need to be had. And I think The Onion did a brilliant job at bringing that to light. So 1010 would recommend, love a legal brief. Don't normally read Supreme Court briefs. Normally they're boring as fuck. That was not boring at all. And I think they made their point very, very well. So with that, let's take a look at some of our questions, and then I should probably go eat lunch. Truthfully. And I've got some work to do. Today we have some office work we have to get done. I mean, work, other than getting to talk about y'all. J. Michael RN told me to stop the ageism. You're not old. We are the same age, and I refuse to be labeled as old. You are not under attack. When I say that I am old, I need to clarify that my soul feels very old. Like, though my body might be in my 40s, there are times my soul is a very, very old woman. And, people want to Netflix and chill. I want to blanket and tea. Question, where is the part where the Latin is translated? There is no part where the Latin is translated. I can send it to y'all. Hold on, let me post there's a public link to the brief. I will grab it after the stream and post a link to the brief so you guys can grab the brief if anybody wants to translate it. It would be easy to do on Google Translate. Google Translate does Latin. Zeta O says, look at SNL, for example. This is a TV show that is all about parody. Is this program that should be considered? The SNL is exactly it. It pokes fun at political leaders quite a lot and should be allowed to. Did you see that David Dobrik posted his response to the Jeff situation? No. Where did he did the court? Hold on. Now I want to go to the court's website and see if it's on the court's website. Pause, please. Pause, please. We're just gonna go take a look at the court's website and see if like a legal response or like a social media response. So I'm pausing here because I'm not gonna look at the chat as I go to the court, and I have to find my case number real quick because now I'm curious. And the mods are like, no, not a tangent. Sorry, look, I haven't streamed in ages and ages, and I have a very busy week next week. It's a long one today. That's what timestamps are for. Replay crew that have gotten this far, the love is undeniable for you. Let us go look at the response to the Dobrik situation. I mean, I assumed it would settle before there'd be a response in court. True story. And we haven't looked back at it in a while, but I'm most curious about who his lawyers are because there were rumors about who his lawyers were. Let's see. Which means I just switched my screens around. And if I'm going to pull something up from the court website, we got to switch our screens back around. All right. Let's see. Bondi Adam, attorney for defendant. Is that somebody from... Well, the attorney has appeared in the case, which is new. Who's Adam Bondi? All right, hold on. Let's see if they're from Brown Redneck. Now I'm curious. Let me go through all my login stuff, and we'll take a look. Darn it. The LA court system website is not fantastic. Oh, I see that there's an answer. But the answer was... that answer was filed September 21st. So I do see there's an answer. If that's something you guys want me to cover, I can. All right, let's just look real quick. Let me just download it real quick. All right. Who is his attorney? His attorney is not Johnny Depp's attorneys. These attorneys are from not Brown Redneck. But let's see. He answered the case. So let's just, I don't want to do that. Let's just grab it real quick. Yeah, that interestingly, nobody has talked about it. That came out a while ago, but a lot's been going on. So the chat's like, wait, what are we doing? Yes, we're just going to look real quick. Because I imagine it's going to be a form response because that's normally what you get. And it's just going to take a moment. We're going to be focused. Yes, George did just give up. George is like, I don't care. I'm done for the day. Let's see. Give me my document. Let's pull it up. That's how long it takes to pull things up. It is not generally easy. All right, let's just pull this up and take a look real quick. So if David probably posted this on his socials so people could read it because nobody had discovered it because nobody was looking. Let's see. That's not the right screen share. Let's switch screen shares. All right. Riveting as I try. Where is... come on, screen sharing. My screen sharing now does not want to work. Good Lord. Could we make it any more difficult on ourselves? Probably not. Now we're going to have to find out why my screen share won't work. There we go. Let's see. That's not it. That's it. All right. Now we can pull it up. Yay. We fixed it. All right. David Dobrik and David Dobrik LLC's answer to the complaint. This is probably a form answer, correct? Form answer. General denial. We deny. Affirmative defenses. Failure to state a claim. Unclean hands. Superseding intervening cause, which is you did shit too. Comparative negligence. You did shit too. Assumption of the risk. You knew the shit you were going to do and you did it. Waiver. Somehow you waived things. Estoppel, consent, lack of standing. Latches. Failure to mitigate. Excuse. Discharge. Offset. Set off. No damages. Good faith. Actions of others. You did this. No exemplary damages, no malice, arbitration of venue, reservation of rights, and that's it. The defendant says that the plaintiff take nothing by way of the complaint be dismissed, attorney's fees, costs of the suit, that's it. So they answered, this answer is a form templated answer, which is allowable in California. It is just these are our affirmative defenses. These are all of the affirmative defenses, and we're reserving our rights and generally denying everything. Different states make you go line by line and deny things or specifically deny, like admit this allegation, deny that allegation. We saw that in a lot of the Washington filings in the Westbrook business partner lawsuit. But in California, it's like, I deny everything. These are our affirmative defenses, the end, which is the reason I was willing to pull it up because I thought that it might be. We need an ADHD detour emoji. I need another swoop. Like, it's like, we need a swoop that's an ADHD detour swoop. Like that one, but modified. We need a modified swoop for the detour. It's like, like a squirrel just running across the screen. It's like, hold on, rabbit hole. We've detoured to a rabbit hole. But anyway, let's go through some more of the questions. So, no, I did not see it, but now we've seen it. Ryan said, okay, that amicus brief was awesome. Thank you for reading it. We read it because it was funny. And we needed some funny, but it also, we love a funny, but also it not just raises the issues we were talking about today, but raises important conversations that I think need to be had and aren't always easy to have online. Conversations of the boundaries of offense and the boundaries of comedy and what can and can't be said and where that's okay and where that's not okay. And I think, again, we're going through a shift where people aren't as tolerant, especially of punching down humor, which generally, I mean, most of the comedians I like don't punch down. They tend to, observational humor tends to be a little bit more my speed, but there's a lot of room for conversation about where those boundaries are and where they should be and what we tolerate as a society being like, we don't like that, or, oh, we do. But when it comes to this particular case, where the government's overreaching into you're making fun of us and we arrest you is a whole different thing than boundaries of like, oh, that's not for me, or, oh, that violates terms of service on a platform, or, oh, our platform's being transparent in what their boundaries are. Which is what I always strive to do here, is be transparent with what the boundaries are of what we think is okay. And that's what it is. All the happy squirrels said, I need that swoop 17,000 times a day. I mean, yeah, I hear it sometimes in my brain. I'm like, swoop. Swoop, swoop. Merrick said, hi, Emily. Hot topic right now. Try Guys. I've seen lots. I mean, my whole homepage, YouTube, I think, is changing the way they recommend content a little bit. But because I'm not seeing on my homepage nearly as many people as I subscribe to, I'm seeing a lot of recommended content. So much of it's about the Try Guys. As a German, I'm very confused how someone can legally be sacked from his own company or part owner because of an affair. Could you explain, please? I can explain why I can't all the way explain, because we have not seen the employment contracts. We have not seen what they decided was okay for the company, not okay for the company. And the person he was engaged in the affair with was also an employee who he may or may not have been in kind of a supervisory role over, which creates other employment law issues and opens the company up for potential liability. So it really depends, but it seems that there was an agreement to step down. And so it seems that there was no fighting the agreement to step down, that there was an internal investigation, and that under the contract, those things are a problem. I think the bigger problem is that the person that the affair was with was also an employee, which is a little bit of a different situation than somebody who is having an affair with not somebody who works in the company, and whether that impacts the workplace or not. So hopefully that makes sense, but we just don't know enough about what their contracts said, and we don't really know what was agreed upon. It might have been like, what is happening? You've put our company at risk, you've put our reputation at risk, you've done all of these things, and we are out, and we need you to agree to leave. But yes, there could also be an ethics or morality clause, and we also see much more. It depends on when their contracts were written, but you also see clauses that are like putting the company in a bad light. And so negative publicity can also be one of those things that might be grounds to terminate a contract. So I'm going to continue on with our questions. Are you going to go through the answers from KJ to 7M? When they are posted on the court website, I will go through them, because when I cover one side, I try to also cover the other side when they are filed in court. But as of Tuesday, when I covered that, I had not seen anything. And let's go look. If there is anything, I'll tell you that there is, and then we'll cover it another time, because it will need more time than we have while we're doing questions. And I am getting hungry. But let me pull up the docket's really easy to take a look at. Oh, I forgot to pull up the docket in Rust. Hold on, squirrel. We're going to pull up the docket in Rust real quick, because I had a point to make. Professionals, we're professionals here. Okay, let's talk about the docket in Rust real quick. Let me go back to my other screen share. The reason I wanted to pull up the docket in Rust, because it tells us not just that the suit is not, or the settlement's not approved by the court yet, but it tells us what actions they're taking to get it approved by the court. And that is what's important. But now my screen share is also being cranky. Let's see. That's what we need. All right, let's go ahead and share this screen real quick, and I'm going to show you the docket from the Rust case. This is the New Mexico case lookup. All of this is public record and public information, but the things I wanted to show you were the last couple entries here. I know it's hard to see, but they appointed a guardian ad litem, and there was a unopposed motion sealed for the appointment of a guardian ad litem, and an order partially sealing the file of a hearing related to the minor plaintiff. So these things all just recently happened. September 30th, October 3rd, October 5th. These, I believe, are all related to the settlement with regard to the minor child. So the court needing to approve the settlement for the minor child, and appointing someone other than the child's father to look out for the best interests of the child, to review and tell the court what they think of the settlement. So I think that is why we're seeing a guardian ad litem appointed for the minor child of Helena Hutchins to review the potential settlement agreement before the court approves it. Because though the settlement agreement has been reached, the court has not approved the settlement agreement, and the settlement agreement involves the minor child. I think it's appropriate to say, not just let the father decide, but also have a neutral third party appointed by the court decide. So I wanted to show you that, and totally forgot to. So as I was going to look for another docket, I wanted to talk to this docket. So that that happened. Now let me get back to the question that was at hand. Now that I've covered that, because I'll need to add that. Well, if I clip that down into a podcast, I will need to add that into it. So let's see if there's anything in the court website. One day I'm just going to do a Q&A stream, and we'll just look at stuff as you guys ask me instead of tacking it on to the end of a busier stream. But today's not the day. Let's see what this docket has to say. 10-5 answer. So the answer published on the court's website on the 5th. So it's here. It's 16 pages long. That posted the day after the notice of motion and motion and the remote hearing was set. That remote hearing is still on calendar for default hearing. So yeah, the next stream I will pull the answer and we can answer the answer, but it's 16 pages. We are definitely not going to get to that today. So that posted yesterday on Wednesday, and that's there. I'm sure that someone has covered it at this point. Nate was covering this stuff, so he might have covered it on his channel. I don't know. All right. Let's see. This is a question about the Try Guys. Question: is the Try Guys affair a PR problem or somehow illegal? I don't think it's illegal. I think the civil question is that it could put the company at risk because the individual was potentially a subordinate, and that can create employment law issues, but not like illegal, criminally illegal, but it could create employment law problems. And it definitely created a PR problem for the company for sure. Lucinda said the Try Guys is curious to me. If I recall, Ned is the one that created the company and was CFO because he's the one with the business degree. I don't know how you fire someone that intrinsically involved. And their statement was that he's been removed from the company. And that might have been, again, him willfully not willfully, but willingly saying, I will go. They're saying, you need to go. And he said, okay, I'll go. Where we see that go wrong and where we're seeing that being battled out in court is in the Toddy Westbrook business partner case, where she and the business partner are fighting in court. And she's like, we're firing him as an employee, but we can't remove him from the company. He's still a part owner, and they're in court fighting over that because he's like, I'm not going anywhere. So I think with the Try Guys situation, there was an agreement that's just based on their statement that they put out on video. Karen LG Thompson over on Facebook asked, is it hard to set up an online room like yours? I mean, it's a real room. It's my office. And no, it's getting the camera to do the blurry background bits that's the most important. So that. Will you touch on the Danny Masterson case? Love Jelly Boo? Maybe. I'm keeping an eye on it. I don't know. Jana said, what will happen if Tasha K if she really can't pay? Bankruptcy. The thing about bankruptcy is when it comes to willful torts, malicious defamation, is bankruptcy doesn't always discharge everything. Parts maybe, but not everything in the judgment. So if she can't pay, then they can garnish whatever money she makes till it's paid. Did you see the anti-SLAPP laws increasing or decreasing across the country after all these lawsuits have shown up? I think it's something I want to keep an eye on because there's a push and pull, right? Between not trying to silence someone who doesn't have the money to fight back in court, which allows people who are wealthy and powerful to silence those who might criticize them, but also a balance of letting things go to discovery so that people can prove the damage that was done to them. So I don't know if we will see a change state by state. You've got, California has very strong anti-SLAPP laws. A lot of celebrities live in California. Of course they want strong anti-SLAPP laws, but other countries other states have anti-SLAPP laws that really just apply to politicians and apply to political process and don't so much apply to the kind of celebrity and non-political context, if that makes sense. Steve Cast asked, isn't it true that most judgments are hard to collect? Yes. Collection can be very expensive. Also, yes. Yes, and yes. Psychedelic Yoda said, if Tasha K can't pay, do you think this will set precedents for future celebrity defamation suits if a defendant can't pay? I don't think it'll set precedent. It's not uncommon that you get to a lawsuit where you're not going to get the money at the end of it. That's not uncommon. Brian J over at Lakeland Title. Hello. I used to do collection work. It can get wild. Definitely had to get someone to dumpster dive for bank records. Collection work can absolutely get wild. It's something Joe Neerman talks about too. It can be very, very time consuming and expensive. Question, can Baldwin still release Rust? Why hasn't he gone to jail? And what is this judgment, financial and or prison? I have questions, but can they be answered? I think we answered a lot of those, Wise Angel. Can Baldwin still release Rust? Yes, if anyone's willing to take it on to release it. Why hasn't he gone to jail? There's been no charges against anyone, and you have to have charges before anyone can go to jail. And this judgment is a civil settlement. Money is going to be involved. Question from Debbie O. You think Cardi B is being petty? No, I think Cardi B might not have intended to go after securing the money and then was taunted. I don't think that's being petty. I think that's being smart. She might have always intended to go after an attachment. It might not be based on the things that Tasha K said online. That was just my speculation that it could be, because Tasha K went online not long after this and was like, good luck getting me to pay. It could have moved Cardi B towards, fine, we're going to have to try to secure this judgment and we're going to have to go for it. Question, if Tasha K can't pay the $3 million, she probably can't pay her attorneys. So can her attorneys drop her as a client for that? Love from Sweden. The attorneys that took her on for the appeal would have had to sort that out with them, but not paying is one of the things attorneys bring up when the relationship breaks down. I'm sure they secured their bag, or at least secured a retainer before they took on the appeal. So can Cardi B do something about the moved money, or is it just lost? It depends on what can be tracked and if money was actually moved, or if that money was ever there in the first place. Jess said, what the fuck is a supersedis bonds? Are there different kinds? Different places call them different things. Virginia called it a suspension bond. The supersedis bond is the same thing. It's posting the bond so that the other party can't go after the money. So it's the same thing, suspending the collection action. When legal costs are awarded, is that amount continually adjusted as post-verdict stuff keeps those costs rising? No, it is set by the jury at the time of the verdict for the cost of the trial. Though there are times attorneys can ask for attorney's fees after trial, you're not guaranteed attorney's fees, and definitely not guaranteed attorney's fees for collection actions. Can Tasha K face any criminal charges if she doesn't pay Cardi B? Not really. I mean, the only wild situation would be if there was some kind of a court order that wasn't followed through and she got held in contempt in some way, but that's not going to be just a failure to pay. That would have to be a much larger situation. So it's hard to be definitive as a lawyer, like anything's possible, but it's very, 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 very unlikely. We don't put people in debtor's prison. Not being able to pay your debts is not a criminal thing. Generally. I mean, asterisk. Hold on, we need an asterisk. Excluding the IRS and paying the government. Question, can you maybe cover Meghan Markle being sued by her sister Samantha? Miss Vicky May, I have covered the initial suit. I have not followed up on it in a while, but we could. It's been a while. Leanne G makes an excellent point saying, I wish people would stop bringing up celebrities and porn like deep fakes aren't a thing. Absolutely true. And it, I think, was pretty clear that the stuff that Tasha K was talking about was not at all Cardi B. So so let's see. We're going to wow to the dumpster diving. I mean, collection actions get absolutely wild. Absolutely wild. Atmana, I am not covering the Alex Jones suit. If stuff goes down in court that needs to be covered, I will talk about it, but I am not covering the Alex Jones suit. I think they went to closing arguments today. There's a lot of suits going on at the moment, but no, I'm not doing commentary over it. I'm not watching it. It's just, let's see. Debbie J. I've said, what is up with the similarities of Cardi B versus Tasha K and JD versus H? Complaints about evidence not being allowed. Why didn't Tasha K's and or Amber Heard's attorneys not explaining why they weren't allowed? It seems a bit deceptive. To be fair, we have not read the brief, and that's what comes up in almost every single appeal. So in every appeal you're going to see the judge didn't let us bring in the evidence we wanted to bring in. That's part of the solid record is the judge messed up on the evidence. We should have been able to bring in this. We should have been able to keep out that. That is a standard part of every appeal. So it's not that these two cases are common. It's that all appeals are common. And one of the most common things you're going to see in every appeal is we weren't allowed to get in all the evidence we were supposed to get in, and the trial court did it wrong. So that's why. Donna Lee said they reshot The Crow after Brandon Lee was killed. I never watched it. I didn't either, but I know people did. I don't know if people will have the same reaction to Rust or not, because it's not the actor that was killed. It was the cinematographer that was killed. I don't know how people will feel about it. Y'all said in the poll, 88% of you were like, nah, I don't want to see it. NS Anderson said this reads very much like The Show Must Go On, feels a bit icky. It does. It feels weird. Annie Lee asked, could this be why Amber, I see A and my brain goes to AH. AB, Alec Baldwin, needs to sell his Hamptons house. I speculated that yesterday in the reels and shorts that I did. I do have a shorts channel if you want to see them. The quick Emily D. Baker Quick Bits is one of my other YouTube channels. And I did talk about that. Maybe this is why he put the house up for sale, was to put forward a kind of lump sum towards this settlement. It's possible. But insurance might also be involved in this too. Mary said, question related to that. Do you read fantasy words in your head? My brothers with dyslexia both say they skip over the pronunciation until they hear someone else say it generally. I have to hear things. The phonemic awareness is missing. I have to hear things said to be able to pronounce it. And I do skip things over. And even in my head, I won't have a pronunciation. If I look at the word, I won't have a pronunciation for it. It's just like, it's like a void for me. So does the Onion wear briefs? I would have expected boxers. I would have expected boxers too. Maybe they're a boxer brief. Emily, when my husband was in the Army, he heard of moms calling their adult child's chain of command to complain that their hours or treatment standard Army conditions. I can't even. Can you imagine? Like, as a parent, I can't imagine thinking that and just being like, oh, it seems like I should call chain of command and be like, why is my child working these hours? I can't even. So let's see. Question, have you paid attention to the Brooks trial? Some. The judge is letting him get away with all kinds of crap and over-explains every decision repeatedly like he's a child. I do think the judge is over-explaining, which I think is a problem for the judge. I think the judge is trying to be careful to make sure he understands. But the judges generally are supposed to treat pro pers as if they are attorneys. And I don't think this is how this judge would treat an attorney. And I think that runs the risk for the judge. The judge is over-explaining in some, but he's going to be disruptive. It's going to be a problem. It's going to get appealed. And they're going to have to do their best to protect the record. But I think over-explaining actually puts the judge at more risk than protecting the record. Question, did you hear Weinstein and Masterson are doing dueling courtrooms trials? They are on the same floor, in the same courtroom at the same time. One will probably get set out. Both trials can't go at the same time, but I didn't know they were before the same judge. I need to take a look at what judge they're in front of and who the DAs are on those two cases. Because they're probably on the long cause. They're probably on the 9th floor, but I need to take a look. I haven't taken a look at that granularly, but that does happen, that you get high profile, any case in the same courtroom, you'll get multiple cases sent on a day. And sometimes one will trail the other and sometimes one will go to another courtroom for trial, and that can happen. Lanahan said, this lawnmower parenting makes me think of an episode of Black Mirror where the kid has an implant and the mom can block things she does not want the kid to see. That's weird. I really, and maybe it's just me, and this is, again, I'm one person with one perspective based on my own life experiences, which are limited to my own life experiences, but I very much want my kids to learn incrementally how to make good decisions for themselves. And if I never let them make a decision that could go badly for them, not in the physical harm, but in the, hey, maybe you didn't get the grade you wanted. Hey, maybe you didn't make honor roll. if there's never anything at stake, you don't learn how to make decisions. And if they don't learn how to make decisions, how do you learn to be an adult where you have to do nothing but make fucking decisions all the time? All the time. And you have to be able to sustain making decisions all the time. And you have to be able to sustain making a decision and then getting to the end of that decision and being like, oh, there's the consequence of that decision. Fuck, I don't like that at all. Don't do that again. I think kids need to learn that incrementally in ways where it's not life altering. And you can only do that by doing it a little bit at a time and letting kids make choices. Okay, fine. You want to eat all that ice cream? Go ahead. Go ahead. Mom, my stomach hurts. Weird. I wonder what caused that. What do you think caused that result? Oh, but if you never let them try, then they never learn. And if they never learn, then they get out of the house and are like, how do I do laundry? I'm like, how have I not raised a human that knows how to do laundry? Because you might mess it up. Okay, well, you might mess it up. And we'll deal with it. And it's just one of those things that takes engagement and some self-awareness so that your kids making mistakes don't trigger you to feel like it's a reflection on you, and letting your kids figure out who they are as their own humans. And it's not easy. Parenting is not easy. So anyway, AD Kemet says, me as a child, what future value does honor roll provide? I mean, my teen at this point is just like, why? Like, why does it matter? And we had this conversation about, I think, honors math or honors science. We had this conversation about honors classes. And he was like, so if I'm in the honors class, I think it was math, it's harder. So it's going to be more work for me to get the grade that I want to get. Why wouldn't I just be in the other math that's easier, do way less work and get an A? Like, why wouldn't I just make that option? And so we looked at, if you're in this math versus this math, what is your math trajectory in high school going to be like? What classes are you going to get to take? What classes do you want to take because he actually enjoys math? And what kids do you want to be in class with? Like, who's going to be in honors math with you versus who's going to be in the other math with you? Aren't all your friends in your math class this year? And won't all your friends be in that class? And wouldn't you rather be in class with your friends so you guys can all work on your homework together? And that ended up being like oh, that's a really good consideration. I didn't consider who my other peers would be in my class. My kid gets highly distracted by noise. And so he tends to be in or like being in classes where people are paying attention to class. So honors math tended to be a better thing for him. But then he came home and was like, Mom, there's like juniors in my math class. I'm like, child, I was the junior in that math class that also had freshmen in my math class. My senior year, we had an 8th grader in my math class. Math was not great for me. It definitely hurt my pride and ego a little bit, but also dyslexia can make things hard. But we had an 8th grader in my math class. It was mortifying. But what I didn't need was that 8th grader being like, why are you all so dumb? And so I'm looking at him being like, hey, maybe a bit of compassion. Don't judge. Just do your work. Remember, you want to be in class with your kids. And so we are definitely in that back and forth of, why do I want to do this? Why do I want to do that? Susan said, looks better for college if that's an interest. And college, he's also like, well, can't I just like learn things on the internet? He doesn't know if he wants to go to college, and he's working on figuring out whether he wants to go to college, but now he's very involved in band. And so he's like, oh, but if I go to college, I can keep doing this thing that I like doing, which was what I ended up being motivated by. I liked playing water polo. I wanted to play in college. So I was like, I want to do this because I want to do that. So I need to get good enough grades to be able to play and be able to go on to college. And that was the motivating factor for me. The motivating factor wasn't like, well, if you don't go to college, you're not going to, get a job. I was like, and I'll figure it out. Like, I don't mind. I like working at Sports Chalet. Leave me alone. I'm a very good cashier. Leave me be. I could do this and it will be fine. So, Tubby Tilly said, question, what has been your favorite case that you've covered this far? What coming up are you looking forward to covering? Well, there's another food case on the horizon with regard to chocolate bunnies that I am very, very excited to cover. I love food related cases. I love funny cases. I love the 50 Cent penile enhancement case. I think it's hilarious. But I also think it falls within our realm of like, what can you say about people on the internet and how does it impact them? So those are some of the ones. The The heavy cases I think are important to cover, but sometimes they're just a bit energetically more draining. Colin and Cuthbert the Caterpillar, love. It's cheeky, it's fun. At the end of the day, it's all gonna be fine. Like those are the cases I enjoy. Question: is it possible for Samantha Markle's father to amend her lawsuit to add her father as co-plaintiff, because I believe one of her allegations to damage to her father would require? I don't know. I haven't looked back at it. It's a number of you have asked about Meghan Markle's sister's suit. We might have to just do that again soon. Holy said, question: who are the Try Guys? I think in some, they used to be on BuzzFeed, and then they started a YouTube channel, and they try things, and they have a YouTube channel, and they're a group of 4, now 3. And what is Section 230? Section 230 is a section of the government code. I don't remember exactly which government code off the top of my head. I would need to pull it. A section of the government code that governs when you can sue a platform, like it used to be for things that were transmitted over telephone lines or listservs that were transmitted over emails. And can you sue the provider of the internet because somebody transmitted something over the internet? And that's where it started in the 90s. Like, are you able to sue someone for the things that a user transmits over the wires or hosts on a listserv or on a website? Can you sue the host of the website, Amazon Web Services, for some shit that somebody posts on the website? No, you have to sue the person who posts the shit on the website that you think you can sue about. And then you get into the age of social media where it's, Section 230 protection means that if somebody on YouTube says something that they can be sued over, you can't also sue YouTube over it. YouTube is just hosting the video. But does that extend to YouTube being sued for not evenly and consistently applying its own terms of use? There's actually a lawsuit. I need to check back in on it. I pulled it ages ago. There was a lawsuit going on that YouTube wasn't fairly and evenly applying or enforcing its own rules, and they were being sued over that. I need to go take a look at what happened to that lawsuit. It was up in Washington, I think. But where are the boundaries of suing platforms, and can they be sued for things on their platforms? Generally, no, not the content on their platform, but can they be sued for enforcing or not enforcing their own rules? Maybe, but that becomes a little bit more difficult. So it gave all these platforms the room to grow, knowing that they weren't just going to constantly be sued in litigation. And that gave them a lot of protection. But then if people say that they've been wrongly removed from a platform, you can't sue the platform because the platform's making that decision. But then when do they become publishers, and when do they become common carriers, and are they a public square? These are the things when we're trying to apply something. The law that was written before social media was social media. It was really written just in the early days of the internet, listservs, emails, those sorts of things. So how do we take older laws and apply them to modern concepts? And when do we need to start reevaluating that? And nobody wants to reevaluate it because it's hard. It's hard to have these conversations, and it's hard for the government to regulate it, because if the government starts regulating the platforms, are the government regulating speech? Right now, they're giving platforms protections. These are difficult conversations, but they're conversations that don't have an answer, but they need to be had. Section 230 is part of the Communications Decency Act. Thank you. Appreciate it. Marching band, saving the ADH kids everywhere. My 9th grader is a whole new kid between that and the guided studies class with a teacher to support executive functioning. That's fantastic. I love band. I love band kids. I love it. My kid has found so much community with band. That's something I found too. I really tried hard not to tell my kid what to do. I try to let him explore and find the things he wants. And so when he was like, I want to do this, I was like, yay. And I've missed our Friday night lives, but I've also very much enjoyed spending that time with him. Whatever happened to the cookie wars? I don't think there's been any recent filings, but we're not done with cookie wars. I love a food lawsuit. My husband said that when he left home, he didn't realize that vehicle registration and renewal was necessary till he was pulled over and the cop had to explain it. That's me. That's me. Some of that's executive functioning is I forget to do it, but I didn't know that I needed to put oil in my car or change the oil in my car. And I didn't know what the check engine light was until like my engine seized. And my dad was like, because I absolutely called my dad and was like, Dad, my car doesn't work. And he's like, let me come on over there. And he's like, you needed to like change the oil. There's no oil. I had a very old car at the time. You needed to change the oil. I see that you haven't done that and the light's on. That's probably the problem. I'm like, what? And he's like, you need to put oil in the engine. I'm like, huh? He's like, how do you not know this? I'm like, you didn't tell me. How did you not tell me these things? So it's hard sometimes as an adult because you forget that you know things. Like which side of the car the gas cap goes on. There's a little triangle thing. I didn't know that until I was like 30. Emily, you didn't call him when the light turned on? No. I called him when the car stopped working. I was like, it'll be fine. It'll be fine. It'll be fine. I learned what a dipstick was from my dad. And now I drive an electric car that doesn't have oil or that needs to be changed. I know how to plug things in and charge them very well. I'm familiar with it. It's like, we need to plug it in and charge it. My car works the same way. Here for it. So girl, I'm with you. All I know was put the keys in the ignition, had my car for years and still learn things. Right. I once asked my dad what the parentheses with the squiggly line meant, low tire. That's a great description of it. I have to ask these things all the time. And I feel very blessed that even into my mid 40s, I still get to call my dad and ask him things. You know what I learned recently from my friend Kendra Hennessy over at Mother Like a Boss? I texted her a day or two ago because we were having this conversation kind of randomly. And I was talking about the kind of glass bulbs or whatever around our light bulbs in the kitchen. And she's like, the best, because I was talking about how hard they are to clean. She's like, the best way to clean them is to just take them off and put them in the dishwasher. I was like, I'm sorry. What? She's like, no, just take them off and put them in the dishwasher. It was freaking glorious. The inside dried all streak free because they do get a little bit of kitchen grease in them because they're in the kitchen. It took all of that off. It was fucking amazing. And I was like, how does nobody teach me these things? It's like the guy on TikTok. And this is what I hate about TikTok is I forget the creators' names unless it's Elise Myers, who I adore. But the guy on TikTok who's like, things I didn't know till I was in my 30s. I'm like, God, I didn't know those things either. And I follow him religiously on TikTok because half the time I'm like, oh, I didn't know that. New Jersey resident here who still doesn't know how to pump gas. I can't leave the state because of this. I don't know if all of our chat knows that in New Jersey, they pump the gas for you at the gas station. It was very weird to me the first time I was driving around New Jersey by myself and I got out to pump the gas and they're like, get back in your car. Like, what are you doing? And I was like, what do you mean? What am I doing? Why are you touching my thing? Why are you touching the thing? Why are you pumping gas? So I'll admit I love it when I leave New Jersey and actually have to remember how to pump my own gas. Y'all from Jersey, you Jersey residents, share with the chat. Not everybody knows that in New Jersey you don't pump your own gas. I mean, not everybody's been to Oregon pumps your gas also. I didn't know that. Wait, in Canada they pump the gas. Where else do they pump the gas for you? This is like me. Was it a members only that I was talking about weight on my driver's license? It might have been a members only live where I was talking about weight on my driver's license. And I didn't realize that because in California, they put your weight on your driver's license. I didn't realize in Tennessee that they didn't. I just assumed it was there. It's not. But I had gone through TSA and the TSA agent was like, oh my God. I watch you. And I was like, hey, as I'm handing over my driver's license. And in my brain, I'm like, oh my God, my weight's on my driver's license. I don't need people to know that information about me. And then I was talking about it in the members chat and they're like, your weight's not on your license in Tennessee. I'm like, wait, what? Because in California and so many other states, your weight is on your driver's license, which is just rude. But Tennessee doesn't have. So I actually, after the members only chat, enough people had said that I pulled out my driver's license. I was like, holy shit. It's really not there. I just assumed it was because I had driven in California for 40 years of my life. Well, not that long, but however many years of my life from the time I was 16 to the time I was like 40, whatever, lots and lots. Kelly P says we have both full serve and self-serve gas in Canada, depending on the company. There you go. Prefer self-serve, no human contact fuel refilling. Let's see. My college has a gas station that was full service. Alexandria was like, but weight changes. Why put it there? I don't know. It's rude. It's so rude. It's so rude. It's so rude. Spencer Mills said, I remember a meme I saw. If I ever go missing and they put my weight on the missing poster, I'm not coming back. Which is pretty funny. Let's see. It is totally rude. Question, is it illegal to cover my weight on my CDL? I think if it's not permanently covered and it can be taken off, I don't know the laws on modifying. There's probably some rule about modifying your license. I imagine if you put like a little Post-it sticky on it, it wouldn't be a problem. I only learned the symbols on the car screen because my old car was automatic with a manual screen. Upshift is a light. I should have never seen. That's hilarious. The weight on mine is a bit rounded down a lot. Oh, as was mine. I mean, that's a given. You're obviously, I'm like, I'm not updating that. We're leaving the weight from when I was 16. It's obviously not true. We're going to let the lie live. We're going to let the lie live and everyone's going to have to deal with it. Cause why would you put that on there? Which is funny because it was kind of the opposite, like college water polo. So I played women's water polo. My brother played men's water polo. They put out your rosters. I wonder if they changed this, but they put out your rosters with your height and weight every year. And so on the women's team, we were all a little bit taller and a little bit smaller. And on the men's team, I'm looking at these dudes going, that is not how big you are, bro. No. So they would be a little bit taller and a little bit heavier, which was funny. Eddie said, my teen put her actual weight. I love that confidence. Get it? Because we shouldn't care. It shouldn't matter. Why does our weight need to be on our driver's license? It's rude. Height, I get. Hair and eye color, I get. I mean, hair color changes too, but geez. Nobody Knows says there's a YouTube channel called Dad How Do I, and it's wholesome AF. I love that channel, and I love the service it provides because it's really, there's times when you're like, who in my life do I ask if I don't have someone to ask? And I love that the internet, this is what I love about the internet, that the internet can provide that. Like if you don't know a lawyer, you don't have a lawyer in your family, who do you get to ask about what a pro se defendant is or the ins and outs of a pro se trial? And that's, part of why I do what I do and why so many of the lawyers that are on the internet do what they do. It's why Lawyer titled his channel Lawyer. He's like, I wanted to make it more accessible so you have someone to ask. I love that there's so many content creators who are like, you might not have had someone to ask, and I'm here to ask. Hey, Dr. B, what do you need? I'm still talking. I know, I'm almost done. What do you need?
I need your extra car keys.
Why? What did you do with my car keys?
Because your car is blocking my car.
Why is my car blocking your car?
Because I was unloading something and then I closed the trunk.
Did you lock the keys in the car? I don't think you can even lock the keys in the Tesla.
You can. You can. Trust me.
Why don't you have the app on your phone and just use the app? You have the app on your phone. It unlocks with the app.
My phone's in the car.
Well, then that doesn't help. Oh, because it's time to go pick up kids from school because I have been streaming for fuck ever. Okay. Joe Mendoza, will you and Adam interview Jen Shaw at BravoCon? I don't know if Jen Shaw will be at BravoCon, but if she is, I will absolutely try to have a conversation. My hub said that when he left home, he didn't realize vehicle registration and renewal. That's how we got onto this topic about not knowing things. Have you covered anything regarding Brad and Angelina? Academic nut? Yes, I have. I'm amazed it hasn't blown up the same way JD and Amber Heard has. It's because it's not on video yet. That's why. It will. It's the Angelina Jolie Brad Pitt stuff is brewing. It's a very different case, but it's brewing. But the reason Heard and Depp got so visceral is because it was on video every single day streaming. These are just documents. I will absolutely cover the next one on the podcast next week. That's my plan at this point, because the answer was just filed, and so it will be next week's podcast, because today there was not space to cover the new filings, and there's a lot in there that I think is better for the podcast. It's a difficult filing. It covers some of the stuff in the FBI, but yes, I have a whole playlist here and on the podcast of Angelina Jolie. So poor Dr. B, I've so done that. I really didn't think you could lock if the keys were in the Tesla. I didn't think it would lock. The amount of times I locked my keys into my car during law school is embarrassing. First of all, being ADHD in law school is a difficult thing on its own. Second of all, trying to remember all the things you need for class was a thing. And my trunk, the books are so freaking heavy. My trunk would be full of books. So I would get out of my car with my car keys and then put my car keys down and grab my books and then close the trunk. And then I would like, no. So I had to get a new system. And then I ended up with my keys on like a thing I could loop around my neck, because then I didn't have a purse and I didn't throw them into my backpack. I needed, because my backpack was in my trunk, it needed a whole new situation. Like I needed a process to like attach my keys to myself so I didn't put them down in my trunk and lock my car, but it happened for sure. All right. My car won't lock if the keys are in it. It yells at me. I thought my car did the same thing, but apparently not. And with that, y'all, we need to say goodbye. The mods have been here forever. Thank you for a super long stream. We're at almost 4 hours. I will be keeping an eye on the Brooks case. It's streaming on Law and Crime and on Court TV and others around here at on the YouTubes if you want to see it. If he is going to testify, maybe I'll stream commentary on that. We'll just decide as we go. But next week is BravoCon, so the streaming schedule will be a little bit different. So follow me around all the socials if you want to follow me around the socials, and I will keep you posted when I'm streaming. So with that, it is time to say goodbye. Thank you for being here. Thank you for being a law nerd. Thank you for a great conversation about all the things in the world today. And I'll see you in the next one. Don't forget to go check out the podcast, The Emily Show. Okay, bye.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.